To the motion in limine. Counsel ready to proceed?
We are, Your Honor. As a preliminary issue, the state did also file a motion to strike the motion to disqualify. Does the court have a ruling on the motion to strike?
Well, I'll rule on it as we go along, but well, no, I won't. I'm not going to strike the motion based on the length of the brief.
Your Honor, we are largely asking the court to decide the motion to disqualify on the briefs. We have thoroughly briefed the issue, and the state had opportunity to respond. They did not offer anything significant in the matter of substance or that would warrant the calling of witnesses, Your Honor. It's a unique issue that's before the court. This matter continues to be complicated by the close relationship that the lab shares with the prosecutor's office, as evidenced by members of the lab sitting at the prosecutor's table in court today. Your Honor, the court is aware that Ms. Gilson, it's Mr. Rucker's position that Ms. Gilson is a material witness and has valuable information to offer related to the reliability of evidence in this case. It's our understanding that there is impeachment information available from Gilson that may constitute an admission to criminal conduct. We have attempted to address that issue with the prosecutor's office by proposing a stipulation, by proposing the offer of immunity. The prosecutor's office is not willing to do any of that. And Your Honor,
let's speak specifically about the disqualification order. What provision would the prosecutor specifically be disqualified from representing the state of Ohio in this case?
We are arguing that in this case, based on the relationship that the lab shares with the prosecutor's office.
That relationship always exists, right? It's existed for 52 years, right?
It does. It's my understanding that this may be the first time in 52 years where an analyst might be called to testify, and their testimony may include an admission to criminal conduct.
Okay. Is that why? So this is one specific instance where you contend the prosecutor should be disqualified?
Correct, Your Honor. We are not asserting, and it wouldn't be relevant, that the structure of the prosecutor's office and the lab being within the prosecutor's office is overwhelmingly problematic, that there is an issue inherent to every case.
I mean, your motion seems to allude to the fact that that is a problem, because you go through the analysis of other crime laboratories throughout the state of Ohio, and specifically the chart, the organizational chart within the prosecutor's office as it relates to the crime lab. So you seem to indicate that it's a problem that the Lake County prosecutor and the crime lab are intertwined.
Your Honor, it's Mr. Rucker's position that in this case, because of the underlying facts and circumstances and the additional issues that have been brought out in the briefing on these motions, that in Mr. Rucker's case, under these particular facts and circumstances, in light of the issue that occurred in the lab, the issues that occurred in the lab in 2023, and that the samples that were taken in Mr. Rucker's case were part of the exact same batch of tests that brought this issue to light, that in this particular case.
What do you mean the batch of tests?
Peer review, we'll get into this into the Daubert hearing, but I've learned in preparation that peer review is done in batches. So the analyst will complete a batch of tests, and then that's provided to the peer reviewer. Mr. Rucker's test results were within the same batch as at least 6 problematic tests that did lead to Ms. Gilson notifying Mr. Kubik of the issue, Mr. Kubik implementing a corrective action that resulted in Mr. Meader's work being supervised for 6 months.
Okay.
So the timing, the facts of the case, and the makeup of the prosecutor's office are what create a unique conflict in this case. It is not Mr. Rucker's position that this is a conflict that exists in every case where the crime lab might be called to testify.
Care to respond to that, Ms. Eccles?
Your Honor, I'm a little caught off guard because I believe that the motion did indicate that defense counsel believed that the prosecutor's office should be disqualified from any case involving Lake County Crime Lab testing. Nonetheless, narrowing it to this case, which should only be the only relevant issue in this case, I don't believe that that creates a conflict in this case. Defense counsel points to the lab director sitting here at the table with us. I suggest that's no different than any other criminal case when the police officer involved in the case would sit at the trial table. There seems to be some conflating of the incident with Ms. Gilson with some emails relating to peer review of Tyler Meter's testing.
First of all, there's the overall allegation that started out back with the filing of the motion in limine is that because of the problem that arose with Kim Gilson in 2023, and then subsequently corrective actions issued to Tyler Meter also in 2023, are such that they should be excluded. And then on top of that, now comes this motion to disqualify, and I'm unclear how any of that relates to the disqualification issue. And I guess I'll go back to you. How does that relate to disqualifying the prosecutor from representing the state of Ohio in this case? I mean, you indicated that Ms. Gilson may have to testify in the criminal trial, and that represents a conflict for Mr. Colson's office. How does that specifically create a conflict for Mr. Colson's office?
Your Honor, there are, I think the state seems to be...
I'm not worried about what the state contends or doesn't contend. I want to know specifically, you seem to indicate when you started that Gilson's testimony would cement a conflict with Mr. Colson's office, and I don't know how that is.
Your Honor, there are multiple conflicts that are present here, and the conflicting...
What are they? What are the
conflicting
conflicts?
interests are first...
What are the conflicting interests?
The state has a primary and sole duty in this case to pursue justice as it pertains to Mr. Rucker.
Correct.
Consistent
Are
with
they abdicating that duty in this case by Mr. Colson, his office representing the state of Ohio?
Arguably, Your Honor, Mr. Colson's office made employment decisions and disciplinary decisions separate from Mr. Rucker's case that are at issue in these hearings. Additionally, Mr. Colson's office presumably made charging decisions.
Why are they at issue in this hearing? Why are the disciplinary issues or the disciplinary actions, whatever they were, why are they relevant in this case?
Because
such that he should be disqualified.
Because if Ms. Gilson were still had not had those employment issues, it is arguable she would still be an employee of the lab.
But she's not.
And had, Your Honor, in any other case, the prosecutor's office would have filed a motion to quash. The prosecutor's office recently filed motions to quash where...
I don't care what they did or didn't do. For the purpose of this issue, I don't care what they did or didn't do. I want you to tell me specifically why, in light of Ms. Gilson's conduct that led to some disciplinary proceedings, why that should disqualify Mr. Colson's office.
Because they have conflicting interests in the hearing that we are set to have on the Daubert issue.
What are the conflicting interests?
Their interest in maintaining the reputation of the public reputation and esteem of its lab.
How is that implicated if we have the motion in limine hearing?
Because the foundation of Mr. Rucker's argument is that the conduct and the scientific work product produced in the lab over the course of at least 3 years, and specifically within the year that Mr. Rucker's test was tested, fell below scientific standards.
Okay, now.
Meaning not only do they have Mr. Rucker's conviction or potential, his prosecution in mind, they have the finality of more than 1,000 drug cases.
I'm concerned about Mr. Rucker's case. I'm not concerned about any other case because nothing else is before me. Okay?
You are, Your Honor. Unfortunately, this state is not. And
Well,
that's
but
the
I
conflict.
don't care. Okay, that's an issue for a different day if it arises. Okay, the issue is State of Ohio versus Dwayne Rucker. Okay, so let's assume for a minute with your argument that we have the motion to limine hearing and Kim Gilson gets up here and testifies to what everybody seems to know by the record, that she failed to test or retest a sample, which and then put something in the record contrary to that, which then led to the disciplinary proceedings and ultimately her resignation. Everybody knows that, right? We all know that to be true.
Correct.
Okay? So what is it that Mr. Colson's office did that would impact Mr. Rucker such that he should be that Mr. Colson should be disqualified in this case?
Your Honor?
I mean, and I ask that because once they found out something, right? The ultimate duty of a prosecutor is to seek justice, correct? We agree on that, okay? And once that misgiving, we'll call it, of Ms. Gilson was discovered, then they took action against her, correct?
Correct.
Okay, and then as you indicate in your motion or motions, that they then, every sample she tested that had an existing case going on was retested. They've indicated that, right?
That was the state's indication. Yes.
What more should they have done? So where's the conflict? What is he? That presumes he's trying to hide something or cover something when they put it all out there. Here's what happened, and here's the action we took, and here's the action we're going to take. So what's he doing that would warrant disqualification in this case?
Your Honor, the foundation of Mr. Rucker's motion was not prosecutorial misconduct, which is
I understand.
where it feels that we're getting.
I'm not getting there.
Your
I'm
Honor,
asking questions. That's all I'm doing.
Your Honor, perhaps the conflict is not apparent yet. We'd ask you to table that motion, and we will raise it when it
How can let's assume that I disqualified Mr. Colson. Then how can he then defend a motion in limine if he's disqualified? So we have to deal with the disqualification first. So I'm looking for the specific reason that his office should be disqualified in this case. Because that's all I'm dealing with is this case.
Then we would withdraw our motion, because to answer your question at this point would be to do a disservice to Mr. Rucker. The state would know what Ms. Gilson is going to testify to if it had talked to her at all within the last week. It is Ms. Gilson's testimony that is relevant and important to Mr. Rucker's case. It is not what the state is assuming her testimony is or what my purpose in calling her is. But I am not prepared to reveal that at this point in time, and we can do that in the Daubert hearing.
Well, we have so you're withdrawing the motion to disqualify Mr. Colson's office and appoint a special prosecutor?
We would ask the court to withhold its ruling for now.
I'm not withholding the ruling. We're in the midst of arguing this motion. Without resolution of this motion, there's nothing else to consider until it's resolved. It's going to be resolved here in the next handful of minutes, or a dozen minutes, or 24 minutes, okay, after the argument's done. So If you want to continue the argument as to why he should be disqualified, go ahead and do that.
I have a moment to confer with my client.
Yeah.
Your Honor, if I might,
Go ahead.
Ms. Gilson was called here as a court's witness on behalf of the court. So if the court wants to hear from Ms. Gilson
I didn't summon her here.
through your court, we didn't bring her here on for us.
I
We brought her here.
I did nothing to get her here.
Okay.
So you want to consult with Mr. Rucker?
All right, Your Honor, we will not be withdrawing the motion to disqualify, and we would ask the court to rule on the briefs.
Well, you may ask me to rule on the briefs, but I have a lot of questions about what's in the
Okay.
briefs. Ms. Eccles, you want to go ahead?
Yes, Your Honor. The state believes that there is not a conflict of interest in this case. Your Honor has been asking questions about that. I haven't heard the defense articulate what the conflict is in this matter. They seem to vaguely indicate that perhaps they feel like things should have been handled differently within the lab. I'm not clear exactly on how they think it should have been handled. Nonetheless, their disagreement with the handling of Kim Gilson's incident in the lab is not the basis for disqualifying the prosecutor's office. It does not create a conflict. The state doesn't have a conflict of interest with another client of the prosecutor's office. Mr. Colson is not going to be a witness in this matter. Ms. Gilson is here. I don't see any recitation of facts or law that would indicate that there's a conflict of interest with the prosecutor's office in this case.
All right, there's, in the brief in support of this motion, there is the contention that under the Ohio Rules of Professional Conduct 1.7, that Mr. Colson's office should be disqualified. Why is that?
Your Honor, where's the citation to the rule?
This is on page 11 of your brief in support.
The financial considerations and third-party interests contemplated by Rule 1.7, Your Honor, would be the final, first, the county crime lab. It exists within the prosecutor's office. Its employees are paid by the prosecutor's office. Any retesting, the cost is assumed by the prosecutor's office. The third-party interests.
Well, what I mean,
refer to Ms. Gilson.
Let's talk about the financial considerations, because you indicate that these issues invoke financial considerations and third-party interests. But as to financial considerations, what beyond the ordinary expenditure of funds for employees and test materials and testing procedures, how is that any different from any other case that the lab handles?
Well, retesting was at issue here, Your Honor, and I myself reached out to the prosecutor in this case in March when I realized the timing and the analysts involved in the case, and asked the prosecutor if he intended to retest the evidence, and he did not. I don't know why he chose to make that decision, or I won't speculate as to why. However, retesting of the evidence would have eliminated the problem here.
Okay, but
That would be
where specifically under 1.7 are there financial considerations such that he should be disqualified?
The financial considerations run through the cost of defending their additional convictions that could be unsettled by the hearing, and the
But once again, we're here about Mr. Rucker. I'm not here about any other case or any other consideration.
Your Honor, it's Mr. Rucker's position that the multiple conflicting interests that are invoked for the state when litigating Mr. Rucker's case are what creates the conflict here.
What are the other conflicting interests in Mr. Rucker's case?
It is the outside interests of the office, the interests outside of Mr. Rucker's case, and how they conflict with
What?
the pursuit of justice in Mr. Rucker's case.
Specifically what, though? What other outside interests?
Defending its charging decisions, defending its disciplinary decisions, not only as to Gilson, but as to Tyler Meter, defending the reliability of the work product of its lab in 2023 and perhaps years prior. Those are all absolutely interests that are held by the prosecutor's office.
I mean, that's just kind of stuff that's out there. You're not telling me, I need specifics, because it's pretty rare, you would admit, to disqualify an elected prosecutor in his office from prosecuting your case, right?
Correct.
Okay, so what's so special, specifically, not that something may result from the 2023 stuff, or Mr. Meter, or Mr. Gilson, or Mr. Kubek, or whoever else. What's specific? Because you got to have a darn good reason to disqualify the prosecutor in this case. So what is it in specificity? Because right now all you're telling me is financial considerations and third-party interests. That's fine. Okay, those are categories of things. But what specifically within those categories justifies this action?
Your Honor, what justifies this action is that Mr. Rucker is not going to be able to, anticipates that he's not going to receive a fair trial based on the handling of this hearing by the state because of its multiple competing interests, and that is why he's made the motion.
So let me talk about that for a minute. So what we have in this case, presumably, and I don't know the facts of it, so I'm presuming, and correct me if I'm wrong, is if this goes to trial, Mr. Meter testifies that certain items were received by the Lake County Crime Lab, they were tested, and he goes through his methodology of testing, and as a result of that testing, it turns out that item 001 and item 003 were both positive for cocaine. Am I presuming that that's a correct anticipation of Meter's testimony?
That would be a logical anticipation of Mr.
Okay, and then what I gather from all the pleadings is that after in 002 tested out to be not a drug, rock salt or something of that nature, right?
Correct.
Okay, so once Meter completes his testing, it is then peer reviewed by Ms. Gilson, who confirms what Mr. Meter found, correct? Am I correct in presuming that would be the testimony?
That is consistent with the report provided in discovery.
Okay. And then, from what I further presume, is that at some point, Mr. Kubek went back and did a separate peer review and confirmed what Mr. Meter indicated. Is that right?
May I correct?
Correct. I'm presuming, so
Okay.
correct my presumption.
He didn't do a different peer review. He did the original administrative review, but he went back to examine the data to ensure that the data wasn't corrupted or anything.
Okay.
So he didn't do a formal peer review, but he did a review just for the purposes of ensuring that the data was correct.
In anticipation of testifying in these proceedings? Not the trial, but this stuff.
Just to ensure the accuracy
All
of
right.
the results, Your Honor.
And Dave Green tested the rock salt, or went back and looked at the rock salt?
To make sure it was rock solid.
Okay. So there were, I think in the motion in limine, I think it was F1 through F26 were emails that came from Gilson to Meter, is that correct?
That's correct.
All right, were any of them related to this case, Mr. Rucker's case?
They were all emails from the 22nd were from the same batch as Mr. Rucker's case.
Okay. All right. Did any of them relate to the substance that Meter tested in Mr. Rucker's case?
No, but there were phone calls in addition to the emails that were sent on that day.
Okay. All right. So getting back to 1.7, how does 1.7 impact this case?
Your Honor, if the court does not agree, then the court does not agree, but it's Mr. Rucker's position that the financial interests have guided the state's decision as to retesting in this case.
I don't understand the financial
The-
interest, because you referenced
Well, Your Honor,
having to retest, but they didn't retest, right? So what are the
correct, and we
financial
made the
interests?
choice not to retest.
Right, so what are the financial interests specific to Mr. Rucker's case?
Specific to Mr. Rucker's case, Your Honor, is the reliability of the evidence. The conflicts of interest don't have to do specifically with Mr. Rucker because it's their interest in prosecuting him and pursuing justice that conflicts with the other interests that their office possesses based in part on its structure and also on the multiple roles that that an elected prosecutor carries by nature of statute. It is their interest, their sole and singular interest that should be present in this case, that is pursuing justice in Mr. Rucker's case. Pursuing justice meaning introducing reliable evidence against him.
Is your position is the evidence is unreliable because Ms. Gilson peer-reviewed this and got
No.
disciplined? No?
It's our position that it is unreliable because Tyler Meter's work product was unreliable at least from 2023, and if not from
Unreliable
2018 when he was hired.
Unreliable how?
That would be brought forth through the testimony of Kim Gilson,
Okay.
who primarily she did the vast majority of his peer reviews
Right.
and was situated directly above him in the process
Right?
for, it's my understanding, his entire period of employment at the lab until she separated.
Okay.
This isn't about Kim Gilson. This is about Tyler Meter. Because Tyler Meter tested the drugs in Mr. Rucker's case.
All right. So Tyler Meter did not follow protocol in this case when he tested the cocaine?
He did not follow protocol routinely, so routinely that it was Ms. Gilson's position that if she were in my client's position, she wouldn't be comfortable being convicted with evidence that had been tested by
Well,
Mr. Meter.
That's, I mean, I'm trying to, what I'm trying to do is to find or to elicit something from the defense that is very specific as to the extreme remedy of disqualifying Mr. Colson's office. So, and I'm not hearing it. I mean, financial considerations and third-party interests are categories of things. And I haven't heard anything specific. What more specific do you have for me in either of those two categories?
I don't, Your Honor. The crux of the argument as to Mr. Rucker was the founding conflicts of interest, the multiple interests that the state has based on its role as an elected prosecutor, as well as the
Well, it always has
structure.
multiple interests. I mean, he's got a whole bunch of clients, right?
They aren't all called to the table the way that they are in this case, Your Honor.
What does that mean? I mean, that's not his client. Crime Lab's not his client, right? So there's no client conflict implicated here, is there?
Your Honor, I actually don't know the answer to that question.
Okay.
Whether or not if the crime lab were sued, they would be the county prosecutor's client.
Well, they're not his client. So, I mean,
Okay.
So I'm unclear as to when I started as to what the financial considerations and third-party interest implicated in 1.7 are present for disqualification. What about 3.7?
Your Honor, that issue was remedied by the presence of Ms. Gilson here today.
Okay. Now, what is the perceived conflict as opposed to the actual conflict here?
I'm sorry?
There has to be an actual a conflict, right? What's the you cite an actual breach of confidence. So what is that? What is the actual breach of confidence that's present here?
Your Honor, within Mr. Rucker's case, there's a breach of confidence in that all of the records that we've tried to obtain in order to properly defend Mr. Rucker should have been provided in discovery, and regardless of whether or not they have or were, we've sought them through public records requests. Those public records requests go directly to the prosecutor's office, and the nature and...
Where else would they go? It's the prosecutor's records, right?
But the intimacy in practice as it pertains to this particular case, Your Honor, for example, on Friday, we were still seeking to define which records of Mr. Meters we have and which we do not. And we learned that Mr. Hackman of the prosecutor's office had misspoken, and we had relied on his misspeak in tailoring our public records requests. On a Friday afternoon, we made an additional call to Mr. Hackman to further tailor that request to work through the nuance and the boundaries of our public records request so that it would not be overly
What was the
ambiguous.
request? Wasn't it Meters' file, just personnel file?
Well, there's a debate as to what is contained within the personnel file, which is what Mr. Hackman had referred to, versus where this information is otherwise kept.
All right,
But
hold on. Ms. Eccles, go ahead.
Yes, Your Honor. So there's a misunderstanding here as to what a corrective action is. A corrective action, for the lab's purposes, it's a term of art related to their accreditation. For those of us lay people who are not lab directors, lab employees, and not subject to those sorts of accreditation requirements and not intimately familiar with them, it has the sound of some sort of disciplinary action. It is not that. So there's a misunderstanding here that a corrective action should have been in the personnel file because it's disciplinary.
No,
That's
Hold on,
not
let her
the
speak.
case. The corrective actions in this case related to Mr. Meter were corrective actions in the lab sense, in the accreditation sense. They were not disciplinary. Mr. Hackman had, in a prior email, incorrectly indicated when he sent the corrective actions that they were contained in Mr. Meter's personnel file. They were not, because they're not disciplinary. They're separately maintained as part of the accreditation records. So
What are, I'm asking you this question, exhibits F1 through F26, what are those?
my understanding of those are that those are emails generated as a result of the peer review process in a number of separate cases of testing that Mr. Meter performed.
Are those corrective actions or are those disciplinary actions?
I would say they're neither. The emails themselves are neither.
Okay.
They are simply the peer review process and then asking for the changes that Kim Gilson felt were appropriate based on her
Okay.
peer review process. I believe that some of those emails, or all of them perhaps, did ultimately result in the lab issuing a corrective action plan to address multiple instances of kind of sloppy clerical errors.
Okay.
Your Honor, it's to address a claim of deficiency. Corrective action,
And just, I want to make sure I'm clear. In Mr. Rucker's case, Mr. Rucker's submission to the lab or other submissions to the lab?
I was responding specifically to the state's indication that corrective action results from clerical
Okay.
error. It's specifically related to their accreditation. It's a claim of deficiency. And then once a claim of deficiency is made, because it's deficient performance, the determination as to whether or not corrective action is needed is then made.
All right. So were these, whatever you want to call them, okay, like the broad category of correspondence from Gilson or the lab director or Mr. Colson or anybody else to Meter, did any of them relate to the testing that occurred in Mr. Rucker's case?
Not that I'm aware of, Your Honor.
Okay. So then we were in the midst of talking about 3.7. So how does all this relate to 3.7? Or the actual breach of confidence?
So, circling back to just before the court began speaking, when we were referring to the public records request that was made Friday, that request was made to Dave Hackman because it was necessary for effective representation of Mr. Rucker. And while we're making our public records request and discussing the nuances of the borders of it in order to get what was needed for this hearing, we learned that Mr. Hackman is in the office with Ms. Eccles and Mr. Geigrich and has us on speakerphone.
What does that have to do with this? I mean, you asked Hackman to do something, and Hackman, to my knowledge, isn't involved in the prosecution of Mr. Rucker in this case. So
But the attorneys will-
naturally, they're going to talk to Hackman, right?
Because,
So what's the problem with that?
if this court doesn't see a problem, that's this
Well,
court's determination to make.
But you see a problem, and I'm asking you what problem you see with that.
The cumulative, it's the cumulative effect, Your Honor, of what is at issue for the crime lab. The prosecutor's
but what-
responsibility for the crime lab.
What's at issue for the crime lab?
What's an issue for the reliability of its work product
Okay, in this case?
in all cases?
In all cases. So this is going to be, so you anticipate that this is going to be an ongoing problem ad infinitum as long as the structure of the prosecutor's office as it relates to the crime lab exists?
I don't, Your Honor, and
Why not?
in part.
Based on your argument, why not?
Well, first, because we have accepted both the lab's indication and assertion to the county public defender's office, as well as the prosecutor's assertion that the issues identified in 2023 have been corrected. The multiple issues, or issues plural. We are not saying that drugs that were tested in 2024 or 2025 are impacted by these issues, because they finally did something about the problem in 2023, and we assume that they did what they told us that they did. But Mr. Rucker's drugs were tested in 2023, which is why his is one of the last cases likely to invoke any of these issues. It's our understanding, and we accept, and it's not relevant to this case, that the deficiencies in the lab were identified through corrective action and through disciplinary action of Gilson in 2023. We assume that those corrections took care of the issues, but it does not eliminate the issues that were present in 2023 and directly impact Mr. Rucker because his drugs were tested in 2023. That is how this pertains to Mr. Rucker. It is not an argument that that the lab's structure within the prosecutor's office is invalid or creates a conflict in every case. It only does here under these specific issues because of the specific analysts involved, the specific time frame, how it pertains to Mr. Rucker's case, and then now it's prosecution in 2025.
All right, so is this an issue that follows Meter his entire career as long as he works in this field?
It would be our position, well, Your Honor, we have only requested records going back to 2020, in part to limit our public records requests so that they could be satisfied. And also because the crime lab operated on paper prior to 2020. Mr. Meter was hired in 2018. It would be arguable that his work product and performance from 2018 through 2023 would be placed in question.
All right, State wish to say anything in response?
Yes, Your Honor. First of all, I feel like it's necessary to clarify. So there was a significant issue in 2023.
Your Honor, I'm
That
gonna
was with-
No. Let her speak. I let you speak. If I have questions of her, or if you want to respond to her, I'll let you do it. Okay? Go ahead.
There was a significant issue at the lab in 2023 that was involving Ms. Gilson, and that resulted in her resigning prior to her pre-disciplinary hearing. That issue was disclosed not only in the case it was related to, but generally to the public defender's office, because the prosecutor's office believes in being transparent on these kinds of issues, because the goal of the prosecutor's office isn't to just win cases and prosecute people for fun, but it is to pursue justice. Tyler Meter's emails that the defense makes much of were not evidence of a huge deficiency in the lab. They were evidence of the peer review process that the lab has implemented, where they peer review every test.
Why does the lab have a peer review process?
The lab has the peer review process because they take their work very seriously. They want to go above and beyond the minimum standards that are required of them. And so they do that.
Minimum standards required by who?
By the accreditation process.
Okay.
So although they would only be required for purposes of accreditation to do some Q&A on a sample of testing,
This is just false.
they
Listen.
peer review.
Listen, it's her, she's got the floor, okay? And I just told you 5 minutes ago, if you want to respond, I'll let you respond, okay? Go ahead.
So the lab conducts peer review on every test because the reliability of their testing is very important to them. They did that in the cases that led to the emails that were sent from Kim Gilson regarding Tyler Meter's testing. Those emails, none of them involved an issue where the test results were wrong or unreliable or scientifically invalid. These were issues with typographical errors, descriptions that the reviewer thought should be worded a little differently. These were minor issues that did not relate to the validity of the testing. Nonetheless, even if they were more significant, it wouldn't create a conflict of interest for the prosecutor's office. It doesn't create a conflict of interest between the state's interest in pursuing justice and any client of the prosecutor's office, on any personal interest of any particular prosecutor in the prosecutor's office. I mean, those are the considerations when you're talking about Rule 1.7 and a conflict of interest. I did also want to clarify in regards to the financial interest, though I don't think it's necessarily relevant, that the crime lab is not funded by the prosecutor's office. They have their own levy, and they do also get some grant funds. So the prosecutor's office as a whole doesn't have financial impact from retesting in the crime lab. But in any event, the financial interests referred to in Rule 1.7 relate to the personal interest of the attorney. That there's a conflict between the attorney's personal interest because of some financial interest and representing that client. So again, I don't see any basis for disqualifying the prosecutor's office.
All right, Ms. Smith, go ahead, you wanted to respond.
Your Honor, as to the state's assertion that in 2023 they told everyone about this issue and these issues, and refer back to the court's admonition or question as to how does that pertain to Mr. Rucker? Because Mr. Rucker was indicted in September, the end of 2024. He waived extradition in Texas. He wasn't aware of his indictment because it was a secret. When he learned of it, he waived extradition. He was brought here, and he was arraigned on this case in January 2025. Neither of Mr. Rucker's attorneys worked for the Lake County Public Defender's Office in 2023, and none of this information was relayed to us. Additionally,
Well, it was relayed to the Lake County Public Defender's Office, right?
So, and what if Mr. Rucker was?
Well, was it? Am I correct that it was?
I would have no reason to contest it.
You mean you don't know one way or the other whether it was submitted
It
to
is
the?
my understanding that when the Gilson issue arose, it was made known to the Public Defender's Office. There were 2 assistant public defenders at that time who took great interest in the issue, Melissa Blake and Lauren Tuttle. Melissa Blake and Lauren Tuttle both work for the prosecutor's office now. So unlike had they gone to any other prosecutor's office or into private practice where I could have picked up the phone and discussed the issue and what they'd learned with them, that was foreclosed by their employment with the prosecutor's office.
Well,
So what was relayed to
I mean, wouldn't the reverse be true? Let's say that in 2023, Mr. Geigrich was handling Mr. Rucker's case, and in 2024, he had left the office, and Joe Smith was now handling Mr. Rucker's case. Wouldn't Joe Smith be responsible for everything that existed in that file at that time?
in that case file, Your Honor.
Right.
And so the prosecutor's office has one file to maintain. They have one client, the state of Ohio. They are responsible for creating a body of information within that file that builds over time and is passed down through prosecutors. However, as defense attorneys, our file is case specific. It goes to each client.
But wasn't all this information within the records of the Lake County Public Defender?
It was not, Your Honor.
Going back, it was not?
It was not. It was our office's understanding that the assistant public defenders who worked on the issues at that time had saved the information that they collected to our hard drive. It couldn't, and this is not a suggestion of impropriety. However, that file could not be located on our hard drives. All public records requests had to be repeated. Public Defender Clapp repeated those, and we do now have a file on our hard drive where we can continue adding to that and build that information and share it. But the reason
when was that received?
we started rebuilding it in April of 2025 when I became aware of this issue and we started pursuing it.
So nobody had any of these records available until from November of 23 until April of 25?
Your Honor, I wasn't present in the office. I didn't have access to these records when this case was assigned to me, and I was not aware of the issue.
I guess when you say you specifically, I mean, Mr. Rucker is a client of the Lake County Public Defender, okay? Not of Rachel Smith separately from the Lake County Public Defender, the Lake County Public Defender. So anyway, keep on going with your response to Ms. Eccles.
Mr. Rucker is, but Mr. Rucker also has the right to be represented by counsel if
Right.
he's choosing, and should he choose other counsel. And this is
Outside the PD's office.
outside
right?
of the PD's office. They would have no way of even becoming aware of that had they not been actively practicing law in Lake County in 2023.
Okay, but that doesn't exist. We're dealing with what we have in front of us, right? He is.
But what we have is
represented
Mr. Rucker's case.
by
Discovery was provided.
Represented by the Public Defender's Office from the get-go, right?
Correct.
Okay.
The Public Defender's Office, that is my understanding, was under the impression that this was one issue with one analyst. And
When you
that
talk,
anything related.
I want to make sure I'm clear when you're talking about this. When you say one issue with one analyst, you're saying that the other issue with the other analyst is meter.
Correct.
Okay. Go ahead.
And that the issues with the other analyst had been described as clerical in nature, and it is our understanding at this point in time that that is a gross overgeneralization.
All right, well, we'll get to that.
Mhm.
Well, that's the subject if we get to a next motion.
Additionally, in response to what Ms. Eccles put on the record, as to peer review, which also is better suited for the motion in limine, peer review is required by ANAB accreditation standards. It is required by the scientific process and method. It is required under Daubert. Peer review is done not because the prosecutor is going above and beyond to ensure the validity of its results. It is being done because it is a necessary and required part of the scientific process, and this is a scientific laboratory. And Your Honor, as with most of our motions, and we would also like to correct for the record, in the state's most recent reply, it provided an exhibit attached and argues that suggests that Mr. Meter's file was provided to the Public Defender's Office in 2023. If you look at the exhibit just underneath attachments, it shows that delivery failed, meaning Tyler Meter's personnel file was not provided to the prosecutor's office in November 2023 because delivery failed.
So it was never provided until April of '25?
Your Honor, I wasn't present in the office.
I know, but you're within the office. I mean, this,
It's my understanding that we believed that we had it at the time. They may have believed it was provided. Delivery failed,
hey,
Yes, sir.
and then we did not have, we had a belief that we had Tyler Meter's personnel file based on the words of Mr. Hackman from an email that was provided, where it refers to be the record being contained within the personnel file of Mr. Meter. I don't know when or if the Public Defender's Office had Mr. Meter's file prior to this case. If it was present in the office, I sure couldn't find it.
all right, anything else from anybody else? With regard to this motion to disqualify?
Your Honor, I would just like to put on the record that regardless of whether the emails relating to Mr. Meter were received on this case or not, it's still not relevant to whether or not the office should be disqualified from handling this case.
All right, based on the briefs and the argument and the law, the motion to disqualify the Lake County prosecutor is denied. We're going to take about a 10-minute break, and then we'll deal with the motion in limine.
All rise.
As to the analysis of the drugs, is that correct?
That is correct, Your Honor, and it's specifically under the prong of Rule
Can I be
7.
heard briefly, Your Honor?
wait until she's done.
Specifically under the prong of Rule 702 as amended in 2024 to bring it in conformity with the Federal Rule 702 as well as the opinions in Daubert and Hotire.
Go ahead.
Before we move on, it was indicated to the state that that Vanessa Clapp would like to clarify statements that were made as to the records, if the court would entertain that.
Okay.
Your Honor, not so much clarifying misstatements. I think that Rachel spoke as to what she knew was available when she went to look for Mr. Meter's files in 2023. In 2023, I did ask Dave Hackman for the personnel files of Mr. Meter among other folks. It's my understanding that he sent those to us. He sent them to Lauren Tuttle via email. I was out of town at that point in time at a seminar. Lauren indicated in an email to me that she was putting them in a crime lab file so that everybody in the office could have access to us. So I just wanted to clarify that as far as I know, I never looked at the file itself, but as far as I know, Mr. Meter's personnel file, according to the definition that Mr. Hackman used at that time, we've since learned of some confusion about that, but nonetheless, whatever was sent in according to Lauren's email at that point in time. It was moved, according to Lauren, who was our employee at the time, to personnel, to our discovery file, and put under crime lab. And recently, when we went to look into it again for the case at bar, we couldn't find the crime lab file. It was gone. It may have been deleted accidentally. Things get moved around. So at that point in time, then we began trying to recreate that crime lab file so that Rachel could review it. And I again asked Mr. Hackman for the records, and he then did send them to me. So I just want to clarify that. Rachel at that point in time would have no idea what was being sent. When she says she doesn't know what was in there, she doesn't, because she wasn't there. And when she went to look for it, there was nothing there. But that is my recollection of what occurred back in 2023.
All right, thank you. All right, Ms. Smith?
Your Honor, we are asking the court to exclude the drug lab report in this case under the principles of Daubert and Hotire and the Rule 702 as amended in 2024. It's Mr. Rucker's position that Mr. Meter's work in the lab at the time that Mr. Rucker's, the samples in his case were tested, did not reflect a reliable application of the methods approved. It is and Mr. Rucker does intend to establish that through the testimony of Ms. Gilson, and following her testimony, we'll ask the court to grant our motion.
Go ahead, Ms. Gregowicz.
Thank you, Your Honor. There is nothing in Mr. Meter's file that indicates that he violated protocol. He has no disciplinary history, and we don't believe that the defense would be able to show any of this. Thank you.
All right, is it, just so I'm clear before we start, is it the contention of the defense that he did not properly test 001, 2, and 3 under the scientific method that is to be utilized to test those substances?
Your Honor, the test employed in Daubert and Hotire is regardless of the result. It's not Mr. Rucker's position that
I'm not even asking about the result. I'm asking about the method by which he is bound to test those items. Did he follow that method?
It is our position that the analyst in this case overwhelmingly did not hit that his work product does not reflect a reliable application of the scientific methods necessary to produce reliable results. Testimony will bear out whether his work was deficient as reflected in the report, and whether or not corrective action was needed to remedy that deficiency.
In this case?
Your Honor, the deficiency encompasses a time period from January of 2023, which is before Mr. Rucker's sample was received by the lab, through March and April, where the controlled buy was done, the sample was submitted to the lab, through July 22nd, which is the day that Kim Gilson did the peer review of Mr. Rucker's case and Mr. Meter's deficiencies were brought to Mr. Kubik's attention.
All right. I guess that's why I asked that question. Is it, I understand that your position is that Mr. Meter had a whole bunch of screw-ups in 2023, but what I'm asking, did he follow the proper scientific method when he tested 001, 002, and 003 in this case, regardless of any other screw-ups? I guess that's I'm just trying to clarify what the issue is.
It's our position that peer review elicited and uncovered Mr. Meter's deficient work, and as a result of his deficient work for the time period encompassing Mr. Rucker's test, that under Rule 702, Mr. Meter's work product in that time frame does not represent a reliable application of the scientific methods that he sought to employ.
I presume Mr. Meter is your first witness?
It's the state's burden.
Well, I don't think it's the state's burden. It's a motion limiting under 702 to prevent expert testimony.
May we sidebar, Your Honor?
Yeah. Hang on a minute.
Thank you, Your Honor. The State of Ohio would call Tyler Meter.
Hey, Bob,
Yes, sir.
you raise your right hand, please. You swear to testimony I'm about to give is the truth, the whole truth, and nothing but the truth, so help you God.
Thank you, Your Honor. Can you state your name, spell your last name for the record, please?
My name is Tyler Meader. Last name is Meader.
And are you employed?
Yes, I am employed at the Lake County Crime Laboratory.
And what do you do there?
I am a forensic analyst in the Controlled Substance Department as well as in the Toxicology Department.
And how do you get to be a drug chemistry and toxicology analyst?
I graduated from Mercyhurst University with a bachelor's degree in applied forensic science with a concentration in forensic chemistry.
And how does that qualify you to do this?
That gives me the degree necessary to be employed at the Lake County Crime Laboratory. Once I was hired on at the crime lab, I completed an extensive, over a year-long training procedure program that required me to read all of the procedures, watch competent analysts do their casework, have supervised casework, complete a competency test, as well as proficiency tests annually.
Do you go through any additional training besides what the lab provides you?
Yes, each year I attend an annual conference to better my understanding in the field, see more trends happening in the field, and expand my knowledge in the field.
And are you involved with any associations with advances your education in the field?
Yes, I am a member of MAFS, Midwestern Association for Forensic Scientists, as well as MAT, Midwestern Association for Toxicology and Therapeutic Drug Monitoring.
And how long have you been with the Lake County Crime Lab?
I have been employed since October of 2018.
Okay, and have you ever been called to testify in the Lake County Common Pleas Court?
Yes, approximately 13 times prior to today.
That you've actually testified and your opinion was accepted as an expert opinion, is that correct?
That's correct.
All right. Now, I'm going to show you what's been marked as State's Exhibit 1. Do you recognize State's Exhibit 1?
Yes, I do.
And what is it?
This is a copy of the report that I issued in this case.
And how did you...
What's that report date?
The report date is June 6, 23 through June 12th, 2023.
Is that, so the report date is a range, or is it?
That is the date that I completed analysis. The request date was May 1st of 2023.
I want to make sure I have what you're looking at. Does it say report date under laboratory report 6/23/23?
Yes.
Okay,
Oh, sorry. Yeah, June 23rd, 2023.
okay, go ahead.
So, how do you go from testing a sample to having a completed report? Can you explain the process to us just briefly?
I will first go to the locked evidence cage, retrieve the evidence, ensure that all seals are intact. I will then take it back to my workstation. I will create a worksheet. I will open each individual piece of evidence one by one. I will obtain a net weight of that piece of evidence. I will do an FTIR, Fourier transform infrared spectroscopy analysis. I will record that on my worksheet, and then I will prepare a vial for GCMS analysis, which is gas chromatography mass spectrometry.
And what does that tell you?
Following those tests, the FTIR will give a positive identification if a pure substance, and the GCMS will separate out and identify any and all components in a drug mixture.
Okay. And it gives you data, correct?
Yes, it will give the data, which I will then compare that data to laboratory standards that we as in the Lake County Crime Laboratory have run on that instrumentation. We will compare the unknown sample to the certified controls on our instrumentation to make sure everything matches, and then I will create a report based on my analysis of the findings.
So the data that's registered on the machine, is that data saved in the machine?
Yes, it is.
And why is it saved in the machine?
We have to keep a file of all of our analysis accessible at any and all times per an accreditation requirement.
And what's the purpose of that? What do you do with it?
If needed to, I would be able to go back to previous data, reprint, reanalyze to look at what was run in the past.
And who has access to that data?
The laboratory employees.
Okay, so are you familiar with the term peer review?
I am.
What is it?
Peer review, we use the term technical review, which is when another competent analyst does an independent review of my or the author of the report's work. That means they will look over our worksheet, over our data that we created, as well as the report we generated to make sure that what is on our worksheet matches what is on the report. And we did all testing properly according to our procedures in the scientific technologies.
And why is that done?
That is, technical review is an ANAB requirement that at least needs to be done per discipline. However, the Lake County Crime Laboratory, we employ technical review is on 100% of our controlled substance cases.
So for accreditation purposes, are you familiar with your accreditation?
Yes.
Okay. How many times do you have to analyze samples just for the accreditation?
Could you rephrase that?
Just to qualify, to satisfy your accreditation.
The accreditation will spot check work, and they will pull reports to make sure that we have done all of our data properly. And we do all of our data, our reports, everything is done to a T, that we follow our procedures through training manuals, procedures, personnel, and etc.
Okay. So every case doesn't have to be peer reviewed for the accreditation, is that correct?
That is correct. It does not, however, the Lake County Crime Lab, we do a peer or technical review of all of our cases.
When you use the term technical review and peer review, are those interchangeable for what, in your mind, as to what you're testifying to?
Yes,
Okay.
And there's another thing called an administrative review, is that correct?
that's also correct.
And what's that about?
The administration review will look at the grammatical or clerical wording, numbers on the physical report itself. That does not include the data interpretation that a technical review does.
So State's Exhibit 1 that's sitting in front of you, that would be your final report, is that correct?
That's correct.
And that would have went through administrative review, correct?
Yes.
All right. Tell me, you mentioned your worksheet. What are those?
A worksheet is a document that I personally have that does not get put on the report. The worksheet is my notes that I take throughout the case. The worksheet will include what I interpret the evidence description to be. I will use abbreviations as a shorthand so I can copy that to the report. It has my findings from the FTIR analysis as well as GCMS analysis, my initials and the case number, and the dates that I started and finished my report.
You do descriptions on there, that type of thing, correct?
Yes,
And that doesn't go into your report, that's just your notes.
correct. It's my notes, a lot of shorthand.
Now, your worksheet's also part of the peer review process, is it not?
Yes.
And why is that?
The worksheet gives the technical or peer reviewer a quick glance at how I went about my processing. So the worksheet will say the weight that I recorded. Does the weight on the worksheet match the weight that I reported on the report? Is my description, my shorthand description on the worksheet, does that match the description on the report, as well as the conclusions that I found? I have a conclusion on my worksheet as well as on the report.
So it talks about what machines you used, how you did it, what time, that type of thing, is that correct?
Yes.
Okay. And that doesn't go into the report. So State's Exhibit 1 doesn't take into account any of that.
I will copy from my worksheet to the report, but the worksheet is not part of the report.
Okay. Now, there was a time when Kim Gilson was your reviewer, is that correct?
Yes, she would review some of my cases.
Okay. And you were the subject of emails from Kim to you.
That's correct.
And what was the purpose of those?
The purpose of the email was to fix or address clerical errors that I have made on my worksheet, whether that be I missed an abbreviation or she did not like the description that I put on some of my evidence items that I did analysis to.
Kind of like you called a cube a square, and she didn't like that, so you asked you to say cube, correct?
Correct.
Did that have any effect on your work?
No, that did not have any effect on the technical data or my analysis on any of the pieces of evidence. A lot
Now,
was clerical.
Are you able to review these emails?
Yes.
They're sent to you, correct?
That's correct.
And she wants you just to make a correction on your worksheet.
Yes.
All right, so how do you make a correction on your worksheet?
A correction on my worksheet, I will have the worksheet in front of me. They are saved in a PDF format. I will use a red strike through, date and initial, the day that I made the correction that was asked of me.
Are you talking about a correction to when you use the term worksheet, those were your own notes?
That's correct.
All right. Is there a specific form that you use, or it's just on a piece of paper?
It is on just a piece of paper. It's saved as drug worksheet on.
So there's no crime lab form that has worksheet and you make notes on it?
It's an official document through the crime lab, but it's just strictly a notes worksheet for the analyst.
Okay.
Thank you, Your Honor. Now, did there come a time when you were ever issued a corrective action for your process?
Yes, there was.
What was that?
The corrective action placed against me was not disciplinary in any nature. It was more so of an educational training opportunity for me to be more diligent on my work to eliminate the clerical mistakes that I put forth in some of my worksheets and cases.
And did it work?
Yes, it did.
Okay. Now, has your methodology ever been called into question?
It has not.
Okay, so there's nothing in your file that says, I used the wrong machine, or I did this and this is incorrect?
That's correct.
I think there was one thing where they indicated that you cut off testing short. Do you recall that?
I do recall.
And that was actually an error, was it not?
It was not an error. The
No,
test,
the corrective action itself was an error, was it not?
that was the lab's policy to address an issue that I was developing prior to it getting more aggressive.
But that was to deal with the policies on external samples from outside of Lake County and from within Lake County, is that correct?
Yes,
And actually, what you did was correct for an out-of-county, which the sample was, sample.
that is correct.
So that was kind of wrong for them to do that to you, isn't that correct?
Yes,
Because that's not the policy.
that is correct.
So when we talk about your lab sheet, have you ever had?
Hold on a minute. Is that contained in somewhere in F1 to F26?
Yes.
Where?
Just a moment, Your Honor. It would have been 22-1436, Your Honor.
I don't know what you're referring to.
That would be the lab case number.
I know, I'm looking at defense exhibits F1 through F26, which I assume are these emails regarding corrective action, so I don't know.
What was the case number?
Huh?
What was the case number?
What's this one?
Give me that lab number again.
It's 22-1436.
Your Honor, that would be F1.
F1. All right, that F1 is got a from, sent, to, and subject, and the rest of the page is blank.
Your Honor, the subject of that email encompasses its entire nature. A tech review rejection is a complete rejection of the submitted draft.
Okay. So I don't know, Mr. Meter is kind of peripherally described what that is. I'd like to know a little bit more about that.
So, do you recall that at all?
I do recall.
And tell us what it was about.
That case was technically rejected based on I did not test that evidence to bulk testing, which is a requirement of the crime lab for in-county cases. With this being an out-of-county agency, they pay for a per sample analysis. So therefore, I believe I tested 2 of them. I did not test to the bulk amount because that was an out-of-county agency.
That was Chester Township that requested, is that correct?
I believe so, yes. So I did not test to the bulk requirement for our in-county agencies.
But that's what the policy was for out of county testing, is that correct?
Yes, out of county, we automatically do not test to bulk because they incur a fee per sample.
What did you receive from Chester? What request, do you recall what request was made from Chester?
It was, I believe it was a drug analysis request, and if I recall correctly, I believe it was pills or tablets of some sort.
So they gave you a bunch of pills and only requested tests on a certain part of that? Testing,
I always do 2 to start so I can do a double confirmation. However, in this case, there would have had to have been, I believe, more than 10 to reach a bulk level amount.
Okay.
However, I only tested the 2 to get them their result, because if I would have tested the other 8 samples, that would incur an additional $400
Okay.
fee to the agency.
So if it were an in-county agency, you would have tested the entire amount to get the bulk?
That's correct.
Okay. Good. All right, go ahead.
So that's an error on your part. You did what the lab
Well, did what, or what the,
that was.
I don't know. You got to make it clear.
Is there a difference in and out? You're supposed to.
Cases, procedures at the bulk requirement. It doesn't matter how many samples that would be, we will test to the bulk. But
What
with
do you
it,
mean test to the bulk?
test to a bulk amount for charging purposes.
Okay.
With this case being out of county, the procedure is not automatically test to the bulk so that agency does not automatically have to pay the excessive fee as opposed to the 2 samples.
Okay. So what was the lab policy, Lake County Crime Lab policy?
Policy for out of county is do not automatically test to the bulk amount.
Okay.
In county, test the bulk, out of county, do not.
All right, go ahead.
And this was an out-of-county sample, correct?
Correct.
And you did not test to bulk because that was the policy.
That's correct.
And you were issued,
Yes.
and that was probably an error. Would that be fair to say?
That case was part of the corrective action in a whole.
Is it your testimony that corrective action should not have been issued because you followed the lab policy?
I cannot speak to how the corrective action came to be. That would be the supervisor and
The corrective action said to test to the bulk, right?
no.
What did the corrective action, what was the nature of the corrective action?
The nature of the corrective action was for me to be more diligent in my analyses based on my worksheet and the clerical errors that were made on my worksheets.
Then what's all this talk about testing samples specifically and testing to the bulk?
That was,
You told me the county, the crime lab policy is to test what is requested by out-of-county agencies, right?
yes,
Okay, and that's what you did.
yes,
That wasn't the nature of the corrective action?
no.
Okay, I assumed from the testimony that was the nature of the corrective action. Go ahead.
Okay, we're good? I'm going to call you to your attention. Can I rip this? Get a read.
Which one?
What are your on? Take a look at that.
Okay.
Do you recall what's contained in State's Exhibit F, or excuse me, Defense Exhibit F3?
Yes.
And what was that about?
This is an email that I received whenever Kim Gilson was doing a technical review of this lab case. The first portion, the bottom portion of this email, need to fix case number on GCMS data for item 001A. The case number for this case was 23-0077. On my GCMS data, I put 22-0077. A clerical error typically happens whenever it's the change of year, 22 cases to 23 cases. And then the top portion of this email, it says, can you also fix the worksheet so it says white gum cubes, not square gum cubes?
So you wrote square gum cubes and she wanted you to say white gum cubes.
Correct.
So is there anything in a policy about that in the crime lab?
There is not.
Or would that just be a reviewer's preference?
A reviewer's preference.
So a corrective action can be issued due to a reviewer's preference. Would that be fair to say?
It could be.
Or like you're using your worksheet. That's for you, correct?
That's correct.
All right. And you use a certain abbreviation.
Yes.
Is there a list of abbreviations you're supposed to use?
We have, through our procedure, a list of abbreviations that the analyst in the controlled substance section generally uses.
Okay.
Yes.
And you use a different one.
No.
So there's a couple of corrective actions you had where you used the wrong abbreviation, like put P after C.
Yeah, or for PC, for example, is our abbreviation for a plastic container
So you just put C.
instead of the PC. Yes.
So you didn't call it a plastic container, you just called it a container.
Yes.
Did that affect the outcome of your analysis of the drugs?
It did not. That was a clerical mistake.
But it needed to be fixed.
Right. It was correct on the report, not on my handwritten worksheet.
Now you went to Mercyhurst and you took, what did you say, forensic
Yeah, applied forensic science, forensic
Okay.
chemistry, concentration.
chemistry? Did they teach you about writing reports there?
No.
Okay, did they tell you about abbreviations there?
No.
And how do you learn that?
That is learned shorthand on the job.
Okay, so it's kind of like getting out of law school and you write a brief and you have misspellings in your brief and you file it anyhow. Would that be fair to say?
Yes.
Okay. You got to learn somehow.
Right.
And that's the whole idea of this, is to help you. Would that be fair to say?
That's correct.
So of all these 26 times that Kim Gilson wrote you up with an email for corrective action, were any of them disciplinary in nature?
They were not.
Okay. Now I'm calling your attention back to State's Exhibit 1 that's before you. Kim Gilson did the peer review on that, is that correct?
Yes, she did the technical review.
Okay. And did she note any deficiencies on that?
She did not.
Okay, so she has no hesitation in giving you a corrective action. I think it's apparent, correct?
Yes.
So she didn't do it in this case, though?
She did not.
Okay. And that would indicate you did it right?
Yes.
Nothing further.
Smith?
One moment, Your Honor. All right. Tyler, you indicated that when you first started with the lab, you underwent a 1-year-long training process.
Yeah, about a year, maybe a little over a year.
A
Yes.
little bit over. And you started in October of 2018?
Correct.
So is your practical competency test something that you would have been doing at the conclusion of that 1-year-long training?
Yes.
Okay. And you indicated there were no issues on your practical competency test.
I did not say any issues about my issues on the competency test.
Okay. Did you have any issues on your practical competency test?
I do not recall.
Would it surprise you to learn or hear that when you did that practical competency test, you proceeded to run your batch without changing the liner, SEPTA, preparing new text
You know, I'm going to object,
test
she's reading
mixes?
from a document she didn't even show him. He says he
It's
doesn't
my
recall.
question.
Overruled. Go ahead and ask the question.
Preparing new text mixes did not have as sensitive samples bookended with the 1.0 test mix and ran the 10.0 test mix as the last sample of the batch instead of the 1.0 test mix.
Now I'm aware.
Okay.
When was that?
This was Mr. Meter's practical competency test would have been conducted between May 19th and June 4th of 2020.
Okay.
Now, the errors in your test setup, would you describe those as errors?
I should have been more diligent in setting up the quality control mix. However, that was my competency test before I was signed off to do actual casework.
Okay. And your practical competency test, do you recall if you passed the
I-
practical competency test?
I did pass my competency test, or I would not be doing active casework.
Okay, so you were determined to be competent for the purpose of casework or for the purpose of what else would you do?
There was memos issued from my supervisor to the lab director allowing me to do sample preparation as well as data analysis, and I believe those memos were released in June 20th, 2020 and June of 2021 to do my own casework.
So it was June of 21 that you began your own casework?
I believe so, if I remember my dates correctly.
I won't hold you to it. Now, you indicated as part of your ongoing training, you attend an annual conference. Is
Yes,
that correct? Is that an association conference?
that's correct.
Do you do anything additional for continuing education?
If webinars are offered, I will try my best to attend those virtual webinars. Typically, it's definitely the conference and then any additional webinars that are offered and available to us, I will try to attend.
How many academic or scientific webinars do you think that you've attended over the last 2 years?
Over the last how many years?
2 years.
Between webinars and training courses, maybe 15 to 20. Usually try to do about 4 classes a year for the conferences and then various webinars throughout the year.
So you would say that you're a better educated analyst now than you were in 2023?
That's correct.
Okay. Now, you talked a little bit about your previous trial testimony. You said prior to today, you've testified 13 times in trial. Is that accurate?
It's under 15. I think it's 13, but not quite 15 yet.
Perfect. In how many of those cases, if you recall, was the evidence or your testimony challenged?
I don't recall.
Okay, so is it fair to say then that your typical trial testimony consists of coming in, essentially reading your report into the record, relaying the information contained in your report, you answer some basic questions from the defense attorney about your training and experience, and everybody goes home?
Correct.
Or
Occasionally,
at least you do.
correct. Occasionally, I will get a few questions from defense attorneys regarding the testing and how that was done.
Okay, but you would say overwhelmingly of the cases that you've testified to at trial previously, the evidence itself, your work wasn't being challenged.
That's correct.
Now, Mr. Geigrich referred, I'm sorry, when you described your process to us, you talked about checking to see if the seals are intact. If they aren't, is that important?
Yes, that is important.
Okay, so if Ms. Gilson sent you an email about documenting whether or not the seals were intact, that documentation as to the seal is important.
That would be important.
That would be important. And that would,
However, she would not see the original evidence. I am the one that opens the evidence. I create the descriptions. So prior to opening any piece of evidence, I will notate that this piece of evidence is or is not sealed.
and if you miss that notation, that would be critical because it's probably not going to get picked up in peer review, correct?
If I don't say it is sealed,
Whether or not it's sealed.
it could be.
Now, you just talked a little bit about peer review or technical review, and we're using those terms interchangeably, versus administrative review,
Yes.
correct? So administrative review relates to clerical errors, you've testified.
Clerical errors, yes, strictly to the report itself.
So it's the report, the preferred language, the abbreviations, those types of things.
The abbreviations are looked at through the technical review. The administration review strictly just looks at the finished report product.
Okay. And who conducted the administrative reviews in your cases?
I do not recall who did the admin review in this case. Typically, the admin review will be my supervisor, William Kubek, or the lab director, Leon Johannek.
So the technical reviewer, your peer reviewer, did not do the administrative review?
I do not believe so in this case.
And would that be because your peer is not an administrator?
Yes. That's,
Okay. Let's see. So if Mr. Kubik would evaluate your work for clerical errors, and Kimberly Gilson, your peer, did peer review and technical review, would it be safe to say then that the errors identified by Kimberly Gilson are technical errors, and it would be Mr. Kubik that would identify and refer clerical errors back to you?
if Bill,
I would object. That's like confusing, compounded, confusing.
See if you understand, it's overruled.
sorry, can you repeat that again? I'm sorry.
Absolutely. So you previously testified that peer review, which we're also calling technical review, and is done by one of your peers, is your work assessed by another competent analyst. Administrative review isn't done by your peer because they're not an administrator, and that relates to clerical errors.
The clerical errors are found during the technical review while looking at my worksheet. The clerical errors found were not on the physical issued report itself, just on my worksheets, which would be found during the technical review. During the administrative review, those clerical errors on my worksheet would not be seen, and they would have been addressed prior to the admin review anyways.
So the admin review only reviews the contents of the final draft of the reports, and it does not extend into your worksheet and underlying methodology.
That's correct. Well, I'm sorry, the administrative review will see on the report which methodology was used. However, that is seen firsthand by the technical reviewer or peer reviewer.
So just to clarify, the administrative review, when that's done, would not pick up on technical errors that may have occurred during the testing process because they are only looking at the final report.
Correct.
Now, you indicated that a corrective action was implemented and that that's not disciplinary in nature. It's for the purpose of educating you. Is that correct?
Yes, in my instance, the corrective action was not disciplinary in any nature.
And it was to educate you for what purpose?
To be more diligent on my work product to eliminate the clerical errors that I have had in the past that the emails addressed.
And you indicated that corrective action worked.
To my knowledge, yes.
You believed that your work product could benefit from you being more diligent than you were in 2023?
Correct.
And you have in fact benefited from that.
That's correct.
Mr. Geigerich asked you about a tech review rejection.
Yes.
Okay. And referred to the email as a corrective action report. Are the emails that Kimberly Gilson sent you corrective actions in and of themselves?
They are not corrective actions in themselves. However, the compound of the totality of the emails resulted in a corrective action being issued to me to be more diligent, which I believe Bill and or Leanne, if called upon, can speak to the totality of the corrective action further.
And what was the time frame that the totality of these errors occurred within, if you recall?
I don't recall, I believe within a maybe 4 month time frame. I don't recall the totality of when the first email to the last email was sent to me.
Would it surprise you to learn that the first email was sent on January 13th of 2023?
That seems about right.
And then the last emails that were part of the corrective action that you received would have been on June 29th of 2023. Does that strike you as accurate?
Yeah, I believe that's around five months in total, 6 months.
Yeah, January to June, so about 6
Are
months.
those F1 to 26?
That's F1 and F26.
Through, F1 through F26?
Yes, we specifically referred to the first and last two.
Right.
Okay, so it was not any one of these errors in particular that warranted a corrective action, which you indicated you did benefit from.
Yes.
It was the totality and the cumulative effect of the emails and other work that Ms. Gilson reviewed between January, now I'm gonna manage, and July of 2023.
Yeah, I'm aware of only the emails that she sent. Any other work that she reviewed of mine, I am unaware of any clerical errors that I made.
Well, let me ask you this. Did Kim Gilson do most of your peer review from when you started your own casework through when she left the lab?
Initially, when I first got signed off or competency tested past that, I believe Bill Kubek did a lot of them, and then as I did more and more cases, it would just get divvied up between Bill and Kim, whoever was available at that time. But Kim Gilson did do a fair amount of my technical reviews.
Fair to say that since Mr. Kubik has administrative duties and those types of things, that the bulk of your peer review was done by Ms. Gilson in that timeframe?
I would say probably over half of my cases were to
Okay.
Kim.
When Ms. Gilson did your peer reviews, did she only email you?
She emailed a lot, yes, as the emails were printed.
Did she always email you for a correction?
Most of the time, yes, because then I will see the email as soon as I am back at my desk, as opposed to a phone call where this correction might take minutes, hours later.
Were there days when she knew you were at your desk, so she'd just pick up the phone and call you?
Possibly, maybe a few times. I don't recall.
So, Ms. Gilson never initiated a disciplinary action against you, correct?
No, she didn't. Correct.
Ms. Gilson never initiated a corrective action.
No, she didn't.
Okay. she sent you some emails as your peer reviewer.
Correct.
Okay. And then when the volume of emails reached a certain amount, did she then notify Mr. Kubik?
I'm unsure who she notified. I would think that it would be Mr. Kubek and or Leanne. I don't know how that process went.
So she notified somebody in the administration, and then they decided to make the corrective action.
Correct.
And the corrective action wasn't just from one email for a tech review that shouldn't have occurred, or I'm sorry, a tech rejection that should not have been rejected. It was a cumulative effect.
That's correct.
Are you aware of a corrective action ever being implemented for something that was reviewer preference?
I'm not sure.
You said that you're familiar with the lab's accreditation, those requirements and process, correct?
Most of them. I do not know every single bullet point off the top of my head through accredit, but the general overarching theme I am familiar with accreditation.
Okay. You're aware that the corrective action is reported as part of the accreditation?
Yes.
Okay. And are you aware of how a corrective action is initiated?
I am unaware of how the workflow of that process.
Well, it's a three-step process. You've got workflow, you've got the end result, which would be the corrective action if it's determined to be needed. Are you familiar with the term claim of deficiency?
I am not sure.
Okay. You're a scientist, right?
Yes.
Is diligence important in science?
Yes.
Is it important to be careful when you're a scientist?
Yes.
Is it important to not be lazy when you're a scientist?
That's correct.
And part of that is because science comes down to minutia, right? You're dealing with very small amounts of substances, correct?
That's correct.
You're dealing with weights down to the tenths of a gram at times, correct?
Potentially, yes.
Is that something that you would notice if you picked up a tenth of a gram?
No, it's so
Okay,
small.
it's a very small
Right.
amount, correct? And in science, we use abbreviations, right?
Yes.
A lot. And those are fixed abbreviations, correct?
In science, yeah.
Because a lot of times those abbreviations are only different by one letter, right?
Correct.
So are typographical errors a bit more alarming in science and a scientific report than they would be perhaps in a legal brief?
It depends on the context of these abbreviations. With it being on a worksheet, I would say no.
I completely understand that it's context specific. However, is accuracy in your documentation an important part of the scientific process?
The conclusions definitely need
That's a
to
yes
be.
or no question.
It wasn't asked as a yes or no question, Your Honor.
Overruled, answer the question.
Can you please repeat?
Sure. Is accurate notation important in science?
Yes.
Can transcription errors alter the result of the scientific method or a scientific procedure?
It depends on where that transcription occurs. If it's just in a description, it cannot influence the testing outcomes provided the scientific policies and procedures are following properly. If it's just a transcription error on a description, it will not influence the outcome of the result that that instrument.
What if the specific descriptor we're talking about is the name of a drug? Or something that might be a drug with one letter and isn't with another?
That could be an issue if you write the wrong drug down on the worksheet. Then that would be more of a technical error. The processes are wrong, not just a simple clerical error of missing a letter in a abbreviation.
Now, you indicated that you didn't learn abbreviations in school. I'm going to give you a chance to clear that up a little bit. I'm assuming that you learned a lot of scientific abbreviations in school. Is that correct?
In that context, yes.
But there were lab-specific abbreviations that you didn't learn until you started working at the Lake County Crime Lab because those are specific to that lab.
Yes, correct.
Right. Kim Gilson sent you a number of emails. Were any of them disciplinary in nature?
No.
And she did not initiate any corrective action, correct?
She did not.
All right. And I have no further questions, Your Honor.
These emails, F1 through F26, what would you call those?
I don't think he's ever seen them, Your Honor.
The emails from Kim Gilson, one of which you reviewed, F3, what would you call that? Where it said, can you also fix the worksheet so it says the white gum cubes, not square gum cubes? What do you call that email?
I would, call that an email of her telling me, Tyler, there was a clerical or preference error on the worksheet that I would like fixed prior to completing my technical review.
Okay, when was a correct, is it your testimony that a corrective action was issued based upon these emails from Kim Gilson?
I believe so, yes.
All right, what was that corrective action?
I do not recall the actual verbiage of the corrective action as a whole. I do know that while under that corrective action, Mr. Kubek would be the one reviewing all of my casework throughout that corrective action period. And the
what was the corrective action period? Was it January through June of 23?
I believe it was 6 months, possibly a year. I don't recall the.
Okay. All right.
And in that period of time, like I said, he would be the sole person that would do the technical or peer review of all of my work to ensure that the clerical errors that I was committing in the past due to me not being as diligent as I should have been corrected and addressed. And then after that time frame was over, the corrective action was closed, meaning that I was on the right trajectory upward with my clerical errors being eliminated.
Redirect.
So the corrections, the emails are just corrections. They're not corrective action in themselves.
Correct.
Okay. So can you get just a correction without a corrective action?
Yes.
All right. So it's because you got these, which included an extra level of supervision on your work. Is that correct?
Yes.
So somebody else was being very intent on your work.
Yes.
Have you ever been found to have used the wrong methodology?
I have not.
Did you ever use the wrong machine to test the wrong drug?
No.
Nothing further. Thank you.
Recross.
You previously indicated that failing to notate a broken seal could be significant, particularly because nobody would observe you doing it.
Right.
So would you consider it a clerical correction requested by Ms. Gilson when she says that you need to note on the worksheet stating the seal for the plastic containers was broken is just clerical?
If I may explain.
I'm going to object if she even knows what can she see the document?
He's about to explain it, so go ahead and explain it.
Would you like to see the email before?
No, he's going to explain if he needs to. Can you explain that? You were going to explain
Yes.
it. Explain it.
That case is referring to a case the evidence items were syringes. Those are typically submitted in a plastic tube where the agency will seal one end of the tube, and we do not like to cut over agency seal. If possible, we cut somewhere where they do not seal. However, in those plastic containers, I had to cut their seal to get into the evidence. And with that, we usually on our worksheet put a little notation, cut seal to analyze evidence. However, that is not in our policies or procedures to do so. We just like to notate that if asked about it later on.
And what would be the reason that you would like to notate that?
Just to know where we open that piece of evidence, because whenever we seal that up to send back to the agency, I would have to seal over the agency seal already. So it's a preference that we have at the lab.
Is it a preference, or is it because you are handling forensic evidence being tested for the purpose of being introduced against somebody in chain of custody is important?
The chain of custody was never in question. I notated that it was sealed. However, I didn't notate on my worksheet I cut the seal to open it. However, to open any piece of evidence, you either have to cut a seal or cut the packaging somewhere to test that piece of evidence.
And whenever anybody cuts a seal on a piece of evidence, it would be important to document who, when, and under what circumstances in order to preserve the chain of custody. Is that correct?
That is correct. That is all notated in our LIMS chain of custody form, and on that outer packaging will have the date when I opened it as well as my initials.
No further questions.
All right, I want you have F1 through F26 there.
I do.
Hand that to Mr. Meter. I want to talk to him about these exhibits.
Approach.
All right, Mr. Meter, you've addressed F1,
Yes.
and that was the receipt from Chester Township of a specific request of items to be tested. Is that right?
That's correct.
And you did perform that function pursuant to the request?
Yes.
And was that pursuant to the Crime Lab's policy for out-of-county substances?
Yes.
All right, what was the correction that was issued by Kim Gilson on that issue?
On this issue, she tech rejected that, which kicked
Why
that
did she tech reject it?
because I did not test to the bulk amount as we would for an in-county agency. So if this would have been an in-county agency test,
Right, I understand
Yeah.
that, but was there something beyond that you're required to do as a result of Ms. Gilson's email?
prior to this tech rejection, I then called to confirm with Chester that is this okay for you to only test the two as opposed to testing to the bulk amount, and they said yes, that's okay. You did the testing. Fine.
So what were you required to record differently by Ms. Gilson?
On this case, the conversation to Chester, I put that in our synopsis and then reissued that report that I already sent out and then was reviewed.
When the request came in from Chester, was the request to test two specific items?
I don't recall the submission form. They typically test evidence for drugs or controlled substances. Is typically how they, I don't.
So was a correction requested to note with certainty that Chester required only two things to be tested?
Yes, that was the issue at hand.
F2,
F2.
tell me about that request.
Need to fix case number on GCMS data for item 001. The actual case number is 23-0077. In my data on the instrumentation, I had 22-0077, and she requested that I make that the proper year in the case number.
All right, on F3, you've already testified to that one, correct?
Yes.
Here today. Okay, F4, explain that one to me.
F4. Can you fix the descriptions for item 001C, D, and 2C on your worksheet? I don't recall the actual piece of evidence, but I believe that was a grammatical. I think instead of putting PB, which means plastic bag containing, I think I eliminated the C for containing a clerical error on my worksheet.
So your best of your recollections, you put C instead of PC for plastic containers?
Yeah, it was a clerical error on my worksheet.
All right, F5,
F5, need to add dilution dode on GCMS data for item 003. For my initial analysis of item 3, the peak at hand did not meet our acceptance criteria. I then diluted that sample so we would have an acceptable peak. On the diluted sample, I notated dilution. However, on my initial data prep, I did not write, I need to dilute the sample. However, all the testing was done properly. I just did not put that note on my data
So is it your
packet.
testimony you diluted it properly but did not note that on your worksheet?
Yeah, I did not notate that on my data pack, correct.
F6,
F6, fix the description for item 002C on worksheet to say boxes. I believe on my worksheet I just said box instead of boxes, so a clerical, grammatical extra letter on my worksheet.
F7,
F7, ratio for item 1B in data, page 4 should be 48:65. For that, I had my ratio for 48:68, which is a 5 and 8 are right beside each other on the keyboard, and therefore that ratio made my next calculation wrong by a factor of 0.1. However, it was way above our acceptable threshold, and the material at hand was a suspected marijuana sample, which was marijuana.
okay, F8,
F8, item 1C needs to be reported as inconclusive. Report in worksheet, you did the testing with the IR, so this is a reporting. I believe this sample was suspected hash. I did FTIR analysis on that, and I reported on my report no testing performed, as I should have reported inconclusive. However, with her doing the technical review, she caught that, and I changed how I reported it to inconclusive as to no testing performed because I did do FTIR analysis.
what's FTIR analysis?
FTIR analysis is Fourier transformed infrared spectroscopy. It measures the vibrational wavelength patterns of different drugs.
What's IR?
I'm sorry?
You said you did testing with the IR.
Oh, yeah, IR, that is a shorthand for FTIR.
F9,
F9, need to add res to conclusion on worksheet for items 1B and 1C. On my report, I reported, I don't know the drug at hand, but res for residue, and on my worksheet, I just put the compound's name and I omitted residue. However, it was reported correctly.
on the report.
Yeah, the report was correct.
F10,
F10, it's the email states, I don't think you edited your IR, that's shorthand for FTIR data for item 2. It has 4 pages out of order. Whenever I conduct FTIR analysis, our printout consists of 4 pages. 2 pages are the same exact page, which is the search. Another page is a split spectrum and then a stacked spectrum, I'm sorry. Typically, all the time, we will eliminate the second search page and put that first. It's just easier to review. However, with those 4 pages being in there, it is not in our policy or procedure to remove that duplicate page and have them in a specific order.
F11,
F11, can you add C after the second PB on the worksheet for item 2? That means, can you add C for containing after the second PB means plastic bag? So my worksheet would have said PB and then something, and it should have said PBC for plastic bag containing. So a clerical error that I put on my worksheet. However, the report was correct.
well,
12, note on worksheet says PF was as $1 bill. PF is shorthand for paper fold. I wrote as instead of a on my worksheet for clerical.
So it should have read PF was a $1 bill.
Correct.
$13.
13. IR data doesn't seem to have been edited for the data packet. You have all 4 pages present instead of 3, so that was the same issue before. I left the duplicate search page in and didn't put them in order, which again is not a requirement through our procedure in our lab to have done so.
14.
End date is different between report and worksheet. On my worksheet, we have a start date and an end date, which the analysis is complete. And on my report, I put the end date as the date I issued the report, not the day I was done with the physical data analysis of that. So then I corrected the end date to match the worksheet to the report. It says, just to stay consistent with item 1A, you didn't change the sample for item 1B on the THC screen data, pages 14 through 16. I believe in this case, I did 2 replicates, and in my header, I would put item 1A, replicate 1, and replicate 2. However, that is not necessary to do per our requirements. We don't have to say which replicate it is. And because I did that on 1B, she requested, for consistency's sake, that I change 1A to reflect 1B, stating replicate 1 or replicate 2.
On your worksheet?
That was on the data, my data packet.
$16.
16. New note on worksheets stating the seal for the plastic containers was broken. That is what we spoke about previously, how I physically cut the agency seal prior to analysis. And then it says items 8 and 9 missing the P for PC in description. So I did not put P for plastic container, it would have just said the container. So a clerical error on my worksheet.
All right, 17.
17, fix the end date on the report. That was the same issue as a few emails back to make sure the dates on the worksheet accurately match the dates on the report.
The date of you finish the analysis?
Yes.
18.
18 states, can you highlight the date on the balance log? Highlighting the date on the balance log is not a requirement. That is something the analysts do to make it easier on the technical reviewer to make sure the balance was used on the day of analysis. However, everything is listed the date without the highlight. Then it says QC is short for quality control on GCMS on 6.8 does not identify methadone in the library search for the 10.0 test mix. In that instance, methadone is in our quality control mix. I just went back to the data because it's served on our server, printed out the spectrum of methadone to indeed show that methadone is, that peak is methadone, and then nicotine retention time is 2.63. I put 2.64 on my worksheet. However, with our acceptance window, the 263, 264, the substance of nicotine fell within our acceptability window.
All right, 19.
Need weight note on the report. This is not a requirement in our policy procedures in the lab. The weight recorded of the evidence was different from the weight that the agency listed on the evidence submission form. That is notated on my worksheet. However, we do not have to have that note on the physical report itself. And that weight would have been verified by another analyst.
20.
20 says, need the drug documents added to LIMS. That is a clerical error on my part. Prior to issuing the report, I have all of the data, the QC, on my physical desktop computer, and whenever I release the report, we upload those documents to LIMS, and in this case, I just forgot to upload those prior to review. So in this instance, when Kim went to review, there was no documents for her to look at, so she asked me to upload them.
21?
21. Item 3B, you only verified twice, not 3 times. On my worksheet, I would have put an X3 as to opposed of an X2, meaning how many times I did analysis on that piece of evidence. So a clerical error on my part.
So how many times did you review it or verify it?
I verified it twice, and on my worksheet, I put 3 times by mistake.
How many times did you normally verify it?
One or 2, depending on the sample and what is in that piece of evidence.
Did you
So in
normally
this,
review it 3 times?
so in this case, I only did it twice. I
Right.
looked over the data twice. However, I incorrectly wrote I had 3 preparations of that sample as opposed to 2.
But you said the requirement is once or twice.
Yeah, an unknown powder, we will run that 2 times.
All right.
A cocaine sample would be 1 time.
Why would you test it 3 times? And why would you verify it 3 times?
Sometimes things will be tested 3 times. For example, say there's meth, cocaine, and fentanyl in a powder. Prep 1 has meth and cocaine. Prep 2, meth, cocaine, fentanyl. We will then run an additional preparation to see if that fentanyl will be confirmed.
All right, 22?
22. Start date needs changed on the report. That is to reflect the date on my worksheet to match the start date on the report.
23?
23. Need MDMA retention time on the worksheet. This is not a requirement for the crime lab to have any identifiable substance retention time listed on the worksheet. However, that is helpful to the reviewer to quickly see what retention time a substance could come out at. However, this MDMA that I reported was within the acceptability window. I just did not write that time on the worksheet for ease of convenience.
24?
Excuse me. 24 library search is showing a match to duloxetine for item 1. This came in a potential marijuana case. Our library indicated a substance duloxetine in plant material, and I did not print out that peak of duloxetine showing that it is not a cannabinoid, part of the suspected marijuana. I then went back, printed out that peak to show that it indeed was not duloxetine, and then moved on.
25?
25. Report says outer packaging for item 2 is a plastic bag. Worksheet says envelope. Those are shorthand notes that I put on my worksheet. I incorrectly said that it was an envelope as to opposed of the plastic bag as reported. I then went back to check the evidence, and the report was accurate that it was a plastic bag for that item.
26?
26, it says report says item 2E is a PBCPM. Worksheet says PBCPM. I had to add the extra plastic bag PBC on my worksheet for a clerical error.
All right, Mr. Geigrich, any questions with regard to 1 through 26?
So, thank you, Your Honor. On F10, was that because you didn't remove the blank pages like typically?
Oh, yeah, yes, F10, that is speaking of FTIR pages, it prints out 4 sheets. 2 of the 4 are the same search result sheet, so it's a duplicate page that I did not remove, one of the duplicate pages.
And calling your attention to 19. And there's discrepancies in the weights from the police departments.
Yes,
Isn't that constant?
that is a common occurrence.
And why is that?
Typically, the police agencies will weigh their substances in a plastic bag. We don't know their quality control and their balance. When we weigh, I weigh the substances in the lab. Our balances are quality controlled prior to using, and the evidence is weighed outside of the packaging.
Nothing further, thank you.
Smith?
Tyler, just briefly, if you could go back to F18 for me.
Okay.
Could you just indicate the date on that report, please? I'm sorry, the date on that email that it was.
F18,
Yes.
Thursday, June 22nd at 2023.
And F19. The same, please.
F19, June 22nd at June 22nd, 2023 at 10:39.
And the next?
June 22nd, 2023 at 10:48.
And the next.
June 22nd, 2023 at 11:07.
And if you could just continue all the way through F24, please.
June 22nd, 2023, 1:36. That was F22. 23, June 22nd, 2023, 2:09. 24, June 22nd, 2023, 2:31. And 25. I'm sorry, what did you say to go to 26?
Up through F24, please.
Sorry, okay, yeah, that was 24. Sorry.
So exhibits F18, all of the emails that are represented by exhibit F18 through F24.
Yes.
Those were sent on June 22nd of 2023, correct?
Yes.
Now, go back to F24, please. That's the last email that was sent on June 22nd.
Okay.
Explain to me again how the duloxetine peak was left out of the underlying data for your report.
This case is a suspected marijuana or plant material case. The algorithms that our GCMS systems come forth, it breaks apart into fragments, and there's a common ion fragment and different cannabinoids that is common with duloxetine. So our library search will incorrectly identify as a peak, which then us as the analyst have to go and make sure that is or not that peak. And in all the cases, that's our job to go through the peaks and show if it's identifying, is this that or is it not? We don't base our sole report on what does this library say. We physically go in, I'm saying we as the section, but I will go in and look at the peaks to make sure, is this there or is this not there? And in this instance, I missed the duloxetine identification peak initially. And then when she sent this email, I went back, looked at that duloxetine peak, printed it out to show, yes, it identified as duloxetine, but it is not.
Okay. And is removing a peak from a report clerical?
I didn't.
Or missing a peak that should be included in a report?
That could be a technical mistake, which was caught during technical review when she looked. I went back, looked at that peak, and showed that it was not indeed duloxetine.
And you pointed out that exhibits F18 through F24 are all from June 22nd. Are you aware of what date Ms. Gilson reviewed your work on the sample that was taken in Mr. Rucker's case?
I do not recall. I would have to look at the technical review sheet to see the date that she did that.
Provide that to you, could you ascertain that date?
Was it June 22nd?
It was June 22nd.
Det var how we call the answers, like.
Raise your right hand, please. You swear testimony about to give the truth, the whole truth, and nothing but the truth, so help you God. Have a seat.
Thank you. You state your name, spell your last name for the record, please.
Yes, Leanne Shahanek, Suchanek.
Are you employed?
I am.
Where so?
The Lake County Crime Laboratory.
And how long you been at the Lake County Crime Laboratory?
10 years.
And what's your current job title there?
Laboratory Director.
So you're in charge of everything?
Yes.
Okay. How does one become a director of a lab?
It will vary from laboratory to laboratory on their requirements. You generally want someone with some forensic experience. Specifically here, the requirement is to have a minimum of a bachelor's degree and some sort of training in quality and management issues if possible.
And you are in fact a scientist, is that correct?
I am, yes.
And what discipline are you?
DNA.
Okay, and how did you become an expert in DNA?
Experience. I have a associate's degree in medical laboratory technology, a bachelor's degree in clinical laboratory science, and a master's degree in pharmaceutical studies with a concentration in forensic DNA analysis.
Okay, so how long have you been an analyst for?
Since 2001, so 23 and a half years.
Okay, so at one time you were working a section at a crime lab, is that correct?
That's correct, yes.
And you're familiar with policies and procedures, that type thing?
Yes.
And can you tell us what a peer review is? Or what do you call peer review at the crime lab, at the Lake County Crime Lab?
I believe you're referring to technical review.
Okay, and there's 2 levels of review, is that correct?
Yes, there are.
And what are those 2 levels?
Technical review, and we still do institute administrative review.
And what's the difference between the 2?
A technical review is done by another analyst that is competency tested and qualified to review the results. So a drug report would have to be reviewed by a qualified drug analyst. DNA report would have to be reviewed by a qualified DNA analyst. Administrative review is just an overall separate review for any clerical errors in the report. Things that get reviewed are things like agency complaint number, name, any clerical errors that may be there once it's complete for technical review, because we always want to make sure, as best we can, that things are free from any clerical errors before they leave the laboratory.
Okay. And are you familiar with the term corrective action?
Yes, I am.
And what is it?
Corrective action for an ISO accredited laboratory is basically just a tool that's used in quality management for risk mitigation.
So you say ISO accredited laboratory, what does that mean?
We are accredited by ANAB under the International Organization of Standardization. Their accreditation requirements of 17025.
Okay, and what does it mean to be accredited?
It means that you adhere to a set of standards that are supplied by your accrediting body. We actually adhere to 3 sets of standards at the laboratory. The ISO 17025 standards, which are international standards, and they're for any testing laboratory. We also adhere to the AR 3125 accrediting body laboratories. That is an ANAB set of requirements that are specific to forensic laboratories, as well as the DNA quality assurance standards that are put forth by the FBI, that are specific to the DNA department.
And the Lake County Crime Lab is compliant with all, correct?
Yes.
And what happens if you're not compliant?
If you're not compliant, when the accrediting body does an assessment and they find a nonconformity, they identify the nonconformity, what you are not conforming with, and they give you an opportunity to correct that.
And has that ever happened at the Lake County Crime Lab?
Yes, it has.
And when was that?
There have been multiple nonconformities throughout the accreditation process. I can't tell you exactly every one of them. Our latest assessment was this past March, and we had no nonconformities in that assessment.
And so the accrediting agency comes in and does an audit at your lab, is that, how does an accreditation review happen?
Accreditation is a 4-year cycle. So the first of the 4 years is a full assessment where the accrediting body comes in, a lead assessor, as well as technical assessors for each discipline that you do testing in. They review your procedures, they review your policies, they actually observe you do work. One of the requirements is to witness, as well as they do a case file review. So they review all of the aspects of the laboratory. They ask questions. They're here for about a week. Years 2 and 4 are considered management review years. So they review all of the management documents, any proficiency test records, corrective actions, testimony reviews, and things like that. The third year in that 4-year period is what they call an on-site surveillance visit. So they will do, generally it's 2. They select 2 disciplines to review, as well as the management review, and they again come on site, but they're not reviewing every discipline in the laboratory. It's just those that they select, and what they select will vary from each time they come.
Okay. So how is a corrective action important to the accreditation process?
Well, corrective action is actually a way to document when you have an issue or something that may need to be stopped before it can get worse. It's a documentation process. So you identify the issue, and then if it needs to be corrected, you have a corrective action plan, and you do a root cause analysis. Why is this happening? Because we can't correct it until we know exactly why it's happening. Root cause analysis, and then a corrective action plan. You implement your corrective action, and then, if necessary, you monitor for effectiveness.
So what types of things would trigger a corrective action plan?
Potentially anything could trigger a corrective action if it was something that you needed to take action on to keep either something worse from happening or to stop the action altogether. It can be personnel related, it can be procedure related, it can be facilities related. There is no any set thing. It's just if you see something that's undesirable and you want to correct it, you need to document it in a corrective action to show that we have taken action to correct this. We identified that there's a problem and we don't want it to get worse or we don't want it to happen again, so we're taking action to correct it.
And you have to document it,
Correct.
and that's reviewed by the accreditation agency.
Yes, it is.
Okay. And when they're looking at it, what are they looking for?
They're looking to make sure that we meet all the requirements that are set forth in the accreditation requirements for corrective action. Do we have it documented? Did we do a root cause analysis? Did we have a corrective action plan? If we stated that we were going to do monitoring or follow-up action for effectiveness, did we do that? It's just, did we do what we said we were going to do?
And if you don't, what would happen?
We might get another nonconformity for not following the requirements of for a corrective action.
And you could lose your accreditation for, like, say, the drug chemistry section.
Potentially, if we didn't correct things to the extent that they needed to be corrected, or if they thought there was a larger problem and that the results that were being put out by any discipline were questionable, yes, we could lose our accreditation.
So the entire lab would lose its accreditation?
They could issue it for just a discipline, or they could issue it for the entire laboratory.
All right, I'm going to call your attention to Tyler Meter.
Okay?
Okay, and Mr. Meter came under a corrective action plan, is that correct?
That's correct.
And what was the basis for that?
Some emails that were apparently sent to Mr. Meter were brought to Supervisor Kubek's attention. He then brought that to my attention, and we decided that a corrective action might be to the benefit of Mr. Meter. Even though they were clerical in nature, we can strive for perfection, even though we will never be perfect. We are all human. We just wanted to bring it to his attention, and hopefully then he would pay more attention to the tiniest of details in order to give the best output that he could.
Okay, so I guess I was kind of confused that the emails themselves were corrective action.
The emails initiated the corrective action.
Okay, so an email in itself is just a correction? Can you fix this?
Yes, it was just asking for something to be corrected, maybe a misspelling, a mathematical error, something of that nature.
And how often does that occur in peer review?
We're all human, it does occur. I don't want to say frequently, but everybody makes clerical errors.
Okay, so when's the last time you did casework?
Last year.
Last year, did you get any emails for corrections?
Yes, I forgot to put something in my notes.
Okay, and you've been doing this for 25 years?
23 and a half, yes.
Okay, well, all right. So even you from time to time, and that's the whole idea of peer review, wouldn't that be why it's there?
That's actually the exact reason for peer review. We're all human. We all make mistakes. And so to have an extra set of eyes look at something, we want to ensure that the results that are going out of the laboratory are accurate. And so to have two sets of eyes looking at something, that helps ensure that accuracy.
So did Mr. Meter's issues come to your attention at some point?
Yes.
And who brought those to your attention?
His immediate supervisor, who is Assistant Director Kubek.
Okay. And did you have an occasion to review the corrections that were initiated by peer review?
Yes.
And who did the majority of his peer reviews?
Overall, or just for those emails?
Overall.
I do not know specific numbers. I would assume it would have been Kim Gilson.
Okay. Is it unusual that he would have an extraordinary number from one person if everybody's reviewing his work?
I don't really know.
Okay.
Because I don't know the percentage of his cases that were reviewed by Ms. Gilson as opposed to Mr. Kubek.
So at what point, so you're looking at these emails, right?
Yes.
You reviewed them, and you say, oh, you didn't put the P in front of the C, and you didn't do this, you didn't do that. At what point does that rise to corrective action?
There is no defined point that you have to do a corrective action. And I would venture to say that there are many labs that may not have issued action on such a thing. We felt that we wanted to issue the corrective action just to say, hey, we noticed this. We think you can do better. And offer it to him by speaking to him and saying, we believe you can do better. And looking at it as potentially an opportunity for him to improve. Okay,
I'm calling your attention. Right in front of you is Defense Exhibit 21 through 26, I do believe.
Okay.
Defendant uses letters.
What is it?
Defendant uses letters.
So whatever. So it'd
You
be
said, you mean F?
F1 through 26.
You said 21 through 26.
No, it said state, yeah. So it'd be defense exhibit F1 through 26. Is that what you have in front of you?
Yes,
Okay, is that, all of them are there?
yes, it does appear so.
Can you take a moment, look through them? Do you recognize those documents?
Yes.
And how do you recognize them?
They do appear to be the emails that initiated the corrective action.
Okay, and are those kept anywhere?
They are retained in the laboratory's document management system.
And they're subject to public record requests, is that fair to say?
Yes, they are.
And you actually turned those over to the defense, that's how they became a defense exhibit.
I turned them over to Mr. Hackman at the prosecutor's office.
And how long are these emails maintained by the crime lab?
They're in electronic format in our document control system, so they're maintained indefinitely.
Well, how long do you need to keep them for accreditation?
A corrective action for accreditation only has to be maintained for long enough for the accrediting body to review them. Generally speaking, we would consider 4 years.
Okay, so you're gonna maintain those records.
I'm going to maintain the records, yes.
All right. Calling your attention to State's Exhibit, or Defense Exhibit F1. Do you recognize that?
Yes.
And what's that about?
F1 is a tech review rejection. It does not give me any additional information, so I can't tell you exactly what the mistake was that the report was rejected for. Obviously, Ms. Gilson saw something that she wanted to have corrected, and so she issued the reject findings in our LIM system.
So can you tell us what the lab policy for testing drugs for out-of-county cases?
We do accept cases out of county. Exactly what policy are you referring to?
The amount tested.
Such as bulk testing?
You know, let me ask you this. A Lake County agency delivers drugs to the lab for testing.
Mm-hmm.
What's the policy for how much of that should you test?
We are going to test everything, or if there's a bulk amount, we will test up to the maximum bulk amount that we can test.
Okay. And for an out-of-county agency that brings you a sample to be tested, what's the policy for that?
We will test the items that they submit. If they should happen to submit something that would meet a bulk amount, not every county treats bulk amounts the same, nor do they look at how much they need tested. So we will contact them, tell them they have a bulk amount, and ask what their preference is for the testing. Because they are paying per sample to be tested, we don't want to over test and overcharge them when it's not necessary for their prosecutor's office.
Okay, so the Defense Exhibit 1, F1 that's before you, was a Chester Township case.
They would be an out-of-county case, yes.
Right. And he failed to test up the bulk or he failed to test, yeah, he failed to test up to bulk on that. And he was issued a correction for that.
He would not need to test up to bulk unless the agency requested it. It may have been, I don't know, it may have been a lack of the tech reviewer seeing that this was an out-of-county case.
So that could be almost a correction on the tech reviewer.
Could be, yes.
And if he had contacted the police department, they asked him not to go any further, he would have done the right thing here.
That's correct, yes.
And if that was the case, then this shouldn't have been issued, is that correct?
That's correct.
So that's not really incomplete testing,
No, that would not be incomplete testing.
but it would be if it was a Lake County case.
Yes.
Okay. Now, where did you, when you were reviewing Mr. Meter's work, all right, I'm going to call your attention to Defense Exhibit F10, please. What's F10 about?
It appears that Ms. Gilson sent Mr. Meter an email that says, I don't think you edited your IR data for item 002. It has all 4 pages out of order.
Okay, and so what's that?
I am not familiar with the exact order, supposedly, of pages in the drug chemistry section. It looks like she's telling him he has pages that are not in the order that she wants to see them.
And then, what about blank pages? Is there blank pages that come attached to that?
Again, I'm not familiar with the printout. There may be blank pages that can be taken out, but there is no requirement that says pages have to be in a certain order, or if there is a blank page, it has to be taken out. That would
So if
just
he
be
put the
personal
exact
preference.
records that he got into it with a blank page,
That's not incorrect.
so that's more of a preference. thing?
Objection calls for speculation.
Now, you've reviewed all these incidents, is that correct?
Yes.
Where did the majority, all of them actually, where do all these errors occur?
I'm not clear on your question.
Is it on his finished reports?
No, the majority of them are actually his own personal notes.
And his personal notes, how are they created?
So he is, again, putting together a worksheet. They're also the data. Those are work product notes in the laboratory. So you have to type the information in yourself into the instruments or onto a form, and clerical errors do occur.
Okay. And is there a standard for those notes?
A standard.
The standard throughout your laboratory where this is how these notes should be done?
Not necessarily, no. You just have to have the information there to be able to go back to in order to look at it later, or for another person to look at it later and know what you did and what your testing results were.
Okay, because during the course of this hearing, I've been writing notes, and I'll go like this to Kelly, and she has no idea what I wrote down. But I know what I wrote.
Yes, there is also a requirement for it to be such that another person that is reviewing it would be able to look at it and know what you did, when you did it, and if you didn't do something, they would have all that information there.
Okay, so it's part of the peer review process.
It is, well, it's to document what you did,
Right.
to have supporting documentation for your test results, but it has to be such that your reviewer then can follow what you did.
So if I call something a square piece of gum instead of a cube piece of gum,
I don't think that would matter.
Okay, because the reviewer should know what that is, right?
Yes.
Okay, so if I issue a correction saying, call this a cube instead of a square, is that really something he should be corrected for?
No.
Okay. Weight discrepancies between police weights and laboratory weights. How common is that?
It happens, yes.
Okay, and why does it typically happen?
Generally, when a law enforcement agency is going to take a weight prior to submission to the laboratory, they take it in the packaging. When the laboratory takes a weight, we take it without packaging when at all possible.
Because the packaging adds weight to it, is that correct?
That's correct.
So the majority of these are in his notes.
Yes.
And how does a brand new analyst to the lab learn about, this is how we want things done, this is the abbreviation, this is, where do they learn that?
They'll learn it during training. It's a lot to take in during training. There are some things you also don't see during training that you may not see until you're actually working cases. So you train an analyst as best you can, knowing that there are going to be instances of things that, one, they either didn't get to see during training, or two, it's a lot of information they may have forgotten.
Okay, so me sending an email as a peer reviewer saying, hey, use this abbreviation, this is what it's supposed to be in our lab, that's not a bad thing.
No. Really, with abbreviations and things like that, it's repetitive. So the more experience you have with using them, the more you're going to remember what abbreviation you need to put where.
And the only time that the note, his worksheet notes, becomes a problem is if it leads to incorrect data in the final report. Would that be fair to say?
Yes, I would say if the worksheet is discrepant with the data, or if it is incorrect to the point that the wrong information gets put in a report, that would be a problem,
That'd be a
yes.
whole different issue, correct?
That's correct.
If the data is correct and the information's related to a final report correct, then the actual methodology isn't a problem, it's, you're illiterate. Would that be fair to say?
Methodology for the testing, or?
Methodology for the testing.
Well, methodology for the testing, you have to use the approved methodology within the laboratory.
Right.
But a minor clerical error, as long as it is not, a case number, an item number, a mathematical calculation, and notes, it is really not problematic.
Okay. Have you ever received a report from Tyler Meter that was incorrect, that the report itself was incorrect?
Not that I can recall offhand.
That he reported drugs when there were no drugs, or, there were no drugs when there actually were?
Not that I can recall offhand.
Okay. And you've been in the lab the entire time he's been employed there, is that correct?
That's correct,
Okay,
yes.
and how long, you were his supervisor the entire time, is that correct?
He was hired shortly after I became lab director, yes.
Okay, so the entire time that you've been lab director, he's been one of your subordinates?
Yes.
And if this had occurred, you'd be aware of it?
I would hope I would be aware of it, yes.
And that's why you were involved with the corrective action, is that correct?
Yes.
Has Mr. Meter ever been disciplined by the crime lab?
No.
So the extent of his issues were what we've detailed in F1 through 26?
That's correct, yes.
Nothing further, thank you.
Ross?
The totality of Mr. Meter's errors and deficient performance are reflected in defense exhibits F and F1 through 26. That's correct?
Objection as a compound question.
No, it's not. Go ahead and answer.
As far as the corrective action, as far as I know, yes.
That wasn't the question that you answered from the prosecutor, though. His question was whether or not the defense exhibits F1 through 26 represent the totality of Mr. Meter's deficient performance that has occurred in the lab.
As I
Is that
understand to the corrective action that we're referring to, I believe yes.
Are you familiar with the corrective action that was drafted in this case, the formal document corrective action implementation?
I am. I'm not sure that there are other documents that go with that besides these emails.
But there is a section where the person noting the deficiency, the claim of deficiency, indicates the specific deficiency that corrective action is being implemented for, correct?
Well, that claim of deficiency in corrective action is, yes, stated somewhat, but it's to claim what standard we are deficient on.
Your Honor, this is Defense Exhibit F. We're going to do F-0 since the emails have been designated as 1 through 26. This is the actual corrective action implementation that the emails underlie, and they were provided to the defense together. May I approach? I'm handing you what's been
Can I
marked.
see it real quick, John?
This was provided.
Yeah. Well, your link didn't work. Okay, cool. Thank you.
What link didn't work?
Defense discovery.
You didn't get it?
I tried to click on a link, it didn't work. I sent it to Kim, or our IT person.
All right.
This is the first I've learned about
All right.
discovery. So I'm handing you what's been marked as Defense Exhibit F, and it's my understanding that that is the corrective action, essentially, the implementation of the corrective action, but that's the form that summarizes it.
That is the workflow in our system, yes.
Okay, and so there is a box on that form, correct, that's labeled deficiency,
Correct,
and there's a narrative under that deficiency.
correct.
And does that narrative also suggest that the 26 emails in front of us are the totality of deficient work that was observed, has been observed from Mr. Meter from the day he started through now?
It does not.
And is there anything in there that would indicate that there was perhaps deficient work that is not reflected in the 26 emails?
It indicates that, but I have no documentation of that.
And you are familiar with that form?
Yes.
Could you specifically indicate what the deficiency box alludes to that is not included in those emails?
It alludes to phone calls, which there is no documentation of. It also indicates similar clerical errors for toxicology cases, but again, I don't have documentation of that.
Thank you. Now, you're the director of the lab. You are an expert in DNA.
That's correct.
Are you an expert in drug analysis?
No.
In your role as director, are you familiar with the drug analysis process, policies, and procedures?
To an extent, some yes.
Where questions arise regarding drug analysis in the lab, do you tend to defer to the individual who oversees that department of the lab?
If there are questions with the testing,
Sure.
yes.
So you have not done your own review of Tyler Meter's work or the work that was done in this particular case, is that correct?
I don't have the capability to do that. I'm not an expert in the discipline, so I would not be able to review the work product and know whether or not it was accurate.
And it also follows that then you wouldn't be doing the review of the report as you've testified, or the work process of a particular drug analyst.
That's correct.
You are familiar, though, with your lab accreditation and the procedures reporting. In fact, accreditation is something that is primarily handled by you as the director. Is that correct?
That's correct, yes.
Okay. Since 2020, are you aware of how many claims of deficiencies have been reported in the lab?
The exact number off the top of my head, no.
$16 sound about right?
It's
In the last
possible.
5 years?
It's possible.
Do claims of deficiencies usually relate to the performance of an individual analyst, or can it be a lab phenomena, a department issue, and the like?
It could be any of the above.
And are they primarily issues that are larger than one individual or individual issues?
I can't answer that. I'm not really sure what the question is.
My question is, do claims of deficiencies that result in a corrective action implementation, or it's actually the question of whether corrective action is warranted, do those usually have to do with individual lab analysts or larger lab issues?
Again, it could be any of the above.
I understand what could be. So if I were to present you with Defendant's Exhibit I, which is the spreadsheet and breakdown of those 16 claims of deficiencies related to the lab in the last 5 years, would you be able to answer that question?
For that time period, yes.
May I approach? Based on your review of the deficiency reports, do you have an opinion as to whether they tend to involve the specific acts of one analyst, one time, versus larger, widespread problems?
I would say 6 of them are in relation to an individual. The remaining are either procedural or changes that were made in laboratory or things that happened outside of the laboratory.
So 6, based on your review, it appears related to individual conduct.
Just a cursory review, it appears potentially 6, yes.
And of those 6, how many was corrective action required on or needed on?
I would have to go back if you could give me just a moment.
Take your time.
I believe potentially 4.
Now, over the last 5 years, not just in the drug analysis department, but laboratory-wide, how many analysts who do casework has the lab employed?
Right now, we have 10. It has varied from year to year, people leaving, people coming.
So your best guess as to how many different analysts have worked for you in the lab in the last 5 years would be approximately? Suffice to say it's more than 10, since you've got 10 there now. Is that fair?
Not including myself, I would say 11.
Okay. Now, including yourself, because you do sometimes do casework, as you previously testified, and the last time you did casework, you received an email too.
I didn't receive an email. I just had a tech review rejection.
Okay.
And it was noted that I forgot to put a statement in my report, and I added it, and it went out.
And did that correction or tech review rejection result in corrective action?
No,
Do you feel it was warranted in your case for your one email?
no.
But you did feel that corrective action was warranted when Tyler Meter had 26 emails in a short period of time?
For clerical errors, yes.
The phrase clerical errors seems to be a universal favorite of the day.
Objection.
Withdrawn. Speaking of clerical errors, do clerical errors provoke you generally to report significant nonconformities to your accrediting body?
I do not believe this was reported to my accrediting body.
That wasn't my question.
No, I would not.
Okay. And when we talked about corrective action, when the prosecutor did, you indicated that one way a corrective action can be initiated is through the accrediting body's visit to the lab and their assessment. If they know-
Objection, that's a mischaracterization of
Let her
what I
finish the
asked.
question. Go ahead.
You discussed the initiation of corrective action with Mr. Geigerich, correct? And correct?
One way, yes, that it can be initiated is by a nonconformity from the assessment.
And then another way that it can be is if you yourself voluntarily report that to the accrediting body, correct?
Well, I can initiate a corrective action in the laboratory.
Let's talk about whether this case, I don't want to get into the whole lab theory, okay? She's indicated that in this case, that wasn't reported.
So as to clerical errors, we've learned today that it is not a lab policy, procedure, or requirement for weight to be documented on drug lab reports. Is that accurate?
Not that I'm aware of, I'm not sure. The weight is in a report, yes.
And as lab director, do you require the weight of a substance to be included in the report?
I'm going to object, Your Honor, because it's a confusing question between the...
It's not confusing. Does the weight of a drug need to be included in a report?
That is part of department policy, yes.
That is department policy, that the weight does need to be documented in a report.
In the report, yes.
That's-
She said
Yes.
And now we've talked about a drug analyst or even just a scientist's notes as they go through their experiment and their procedure, the notes that they keep. A parallel was drawn to notes scratched during a hearing. As a scientist, would you ever conduct an experiment without keeping notes?
No.
Do you frequently refer to your notes?
To refresh my memory, yes.
Is it important to you as a scientist that the weights, the measurements, retention times, any measurement be accurately recorded in your notes?
Prior to a final report being released, if there is a clerical error, mathematical calculation, that's why we do technical review. But once a report is released, yes, it would be important that they were accurate for the final report.
I'm talking about you yourself as a scientist. When you take notes, when you're doing your experiments and procedures, is it important to you that your notes are accurate?
It is important to me, yes.
What happens if your notes aren't accurate?
That would depend on where the inaccuracy was.
And if you had a clerical error in one of your measurements in your notes, could that impact the outcome of the particular procedure or test that you're doing?
If a reviewer didn't
Not if
catch it, yes.
No, not if I'm asking you as a scientist doing your work, what's important to you? Pretend nobody is going to review your work.
In DNA, every report gets reviewed, so that would never happen.
Do you rely on peer review to catch all your mistakes, or do you rely on peer review to catch all your mistakes?
No, I don't rely on peer review to catch all my mistakes.
Do you strive to provide accurate information in your draft reports?
I strive for perfection. That does not mean I am always going to be perfect.
But as a scientist, you understand that where our humanity comes into play and we make human error, it can impact the outcome.
It can, yes.
Thank you for the questions.
Can you define for me what a claim of deficiency is?
So for this, it is a description of the issue as well as what particular accreditation standards we feel we are deficient in complying with.
Okay, so that applies to accreditation standards?
Yes.
Okay. And where does peer or technical review fit in with the accreditation that you give?
Technical review is a part of the accreditation process. It is up to the laboratory to define the frequency of their peer review process.
Does the accrediting bodies require that every analysis and report that is authored, does it require peer review?
Only for DNA.
The claim of deficiency, was the corrective action of meter, was that a claim of deficiency submitted to the accreditation agency?
No, it was not.
Okay. All right. Redirect.
One second, Your Honor. Just off the top of your head, how many drug samples does the crime lab test a year?
Maybe 4,000 to 5,000
Okay, and how many would Tyler
You said
tested?
4,000 to 5,000?
samples?
Yeah.
Yes.
How many has Tyler tested since 2000, just say between 2020 and 2023?
estimate maybe 2,000 possibly.
So 2,000, and you're a math person, is that correct?
I try to be.
And DNA is pretty math intensive.
Math intensive, yes.
What's 2,000 divided by 26? Or 26 divided by 2,000?
That would be slightly over 1%.
So out of the 2,000 samples he gets rid, he has to correct it 26 times, none of which affects the science. Would that be fair to say?
That would be fair to say, yes.
Okay. And as for the weights, having the correct weight on a lab report is pretty important, correct?
Correct.
Okay. Is the police weight important in the lab report?
No.
Because that's, I think, what Ms. Smith was trying to get at, whether not including the police weight in a final report. Does it ever go in there?
The actual weight, no, it doesn't. What the law enforcement agency weighs and it has no bearing on our weight.
But our weight that we weigh, or your weight, excuse me, I'm starting to mimic you. The weight that the lab report gathers from weighing it outside of the package is what's important. Is that true?
That's correct, yes.
Thank you, nothing further.
Ross?
Was Tyler Meter a drug analyst from 2020 to 2023, the entire time?
No.
Was he a drug lab technician for some period of that time?
Yes.
And what is the difference between a technician and an analyst?
A technician does not perform data interpretation or issue reports.
Is a technician doing their own casework?
To some extent, but they're not interpreting any data or issuing the report. So they're operating under another qualified analyst.
So during the time frame that Tyler Meter was a drug lab technician and not an analyst, he would not have been handling thousands of cases.
No, he potentially would have.
Would he be the primary person responsible for those cases?
It would depend on what aspect of responsibility.
Well, he wasn't approved to do his own testing.
He was not approved to interpret the results, but he was prepping samples and taking weights and making evidence descriptions, yes.
And he would have been doing that with the assistance of somebody else who could analyze the results.
Can you define what you mean by assistance?
Well, to create a report, an analysis has to be done, correct?
Correct.
That analysis has to be interpreted, and it's that interpretation that we get in the report, correct?
Correct.
So if Mr. Meter could not conduct an analysis at that time, but he was preparing samples and doing other tasks within casework-related tasks, then who was doing the analysis that would lead to the report?
The reporting analyst would have done the data interpretation, but
And would it be fair to say then that that analyst assisted the technician in reaching a final result?
not exactly. The technician assisted the analyst in reaching a final result because the analyst is the reporting party.
The analyst is the reporting party. So those would not be cases handled by Meter. They were handled by the analyst while Meter was a technician and he assisted, correct?
Mr. Meter handled the evidence and prepped the samples
And did not do the analysis when he was a technician,
and did
correct?
not perform the data analysis, but he was still handling the samples. He was just not at the time being assisted as in directly somebody standing over there aiding him in prepping the samples.
So during the time that Tyler Meter was a forensic technician and not an analyst, he wasn't processing as many samples. Is that fair to say?
Your use of the term processing, he did not report samples, but he was processing samples, yes. Potentially 1,000 samples in a year as a technician, but none of them were reported with his name on the report, but that doesn't mean he didn't handle them.
My point is he wasn't doing the work alone. Is that correct?
Objection, she's answered that 4 times already.
Or she's
He was.
not
he-
answering
he
it,
was-
it's the problem.
He was processing, as I understood the testimony, processing the samples, but did not analyze, do the final analysis or write the report. Right?
That's correct, yes.
So when the prosecutor talks about how many thousands of cases come through the lab and how many each analyst handles, the estimate might be a little bit overblown when it comes to Tyler, because for part of the time frame at issue, he was not an analyst, and that impacts his performance, what he does.
I can't say whether it's overblown or underblown. I was just giving
Can
a
you say it's
complete.
accurate?
It was an estimate.
Wait,
So can
wait, okay? You know, initially, she was asked how many drug analysis there are in the lab per year, and she said her guess was 4,000 to 5,000, okay? Her guess on meter was a couple thousand. So, I mean, you can try to narrow this down to 0.1% or 0.96% or 1.04%, but it doesn't mean anything.
Because
okay?
all of this is a guess.
Right? Because she's working off of numbers that she's got off the top of her head. So that doesn't mean anything to me at this point.
So would it be fair to say that you have no idea how many samples Tyler has processed in the last 5 years since he started with the lab or in 2023?
That would be accurate.
No further questions.
All right, you can step down. Thank you. Who do you have left?
You know, at this point, the state of Ohio would rest, Your Honor.
All right, let's come back at 1:15.
AI companion. It's basically an AI.
What's the name of this case?
Okay.
And they
When we're doing, yeah,
consider
Robert.
the scales, they don't the scale.
What is,
Okay, so I will
what's the,
give you a call when I'm at my office and have that she is there at 6:30 a.m. every day, and if she can be there, your client can too.
But she brings you food.
Not me. That's only the guys. Did you pinch her?
No.
She's only nice to the men who pinch her ass.
No, Rocky Carlin's her husband, her boyfriend. No, never. She's the fetus, though, and that used to be the smart thing. So move your docket if you're fetus. And she's actually a very good cook, believe it or not, for as nasty as she is.
Plus, her kid's really cute. You want to? I just never saw it.
K.A. had a kid? K.A. Sadula. Kathleen Ann.
That's my understanding.
When?
Being a teenager now.
All right, I've been
They would have
gone,
been youngish when I was in law school.
I've been gone since 2013 from there.
Okay.
So she didn't have any kids when I was there.
Maybe I'm completely wrong.
Because she was kind of old.
She is, oh yeah, she aged out.
So it must, I'm saying it must be
That's-
like immaculate conception, you know, like,
Well, or adopted her.
it's a new Jesus coming.
Child, I don't know.
A new John the Baptist for law and order.
We're all
Because she was old.
Yeah, no, she's aged out, so.
She was supposed to go sail around the world, is what she was supposed to do.
Yeah.
Her and Rocky Carlin were in, they had like a 75-foot sailboat, and they were going to sail around the world.
It's the only time I got something that remotely resembled a smile out of that woman was talking about my mom because she sails too. And I always knew to wear cute shoes if I was in front of Kathleen because if she left my shoes. So if I had a hearing in front of her, I made sure I wore cute shoes.
Rocky Carlin called me motherfucker in open court. Walked by, was walking by the trial table. He was motherfucker. You know, he was suspended from the practice of law.
I don't know who that is.
No.
I'm not familiar
He
with that.
beat up a judge in chambers.
Wow.
Did you know that?
No.
Yes.
Which judge?
I can't remember which judge it was before the test. In chambers.
So you're saying
I
you're
think he got a
not
year for that.
solicited then?
That's why when he was like, you motherfucker, I was like, I know you're old, Rocky, but we had the Army Marine thing going on.
No.
It's like, Rocky, you're old, you don't want to get your ass kicked by a soldier, do you?
Nice. Interesting. I don't know. Still look that up.
Rocky Carlin, yeah, look. All right.
Seated. Smith.
Your Honor, the defense will call Kimberly Gilson to the stand.
All right, when she comes in to testify, I'm going to inform her that if she believes that a question has been asked, the answer would tend to incriminate her. I'm going to inform her that she has the right to exercise her Fifth Amendment right to remain silent, just so you know. You raise your right hand, please. You swear testimony about to give the truth, the whole truth, and nothing but the truth, so help you God.
Hey,
What?
do we have a quick sidebar?
Yeah. All right, Ms. Gilson, before we get started,
when you are asked questions, if you think that the answer to those questions might intend to incriminate you, you have the right to exercise your Fifth Amendment not to testify so that you don't incriminate yourself, just so you know that at the outset, okay? All right, if you have any questions about that, then stop and you can ask, okay? All right, Ms. Smith?
Ms. Gilson, would you please state and spell your name for the record?
My name is Kimberly Gilson, and it's Gilson.
Thank you. Ms. Gilson, as you're aware, well, first, have you ever worked for the Lake County Crime Lab?
Yes, I have.
And what years did you work for the Lake County Crime Lab?
From 2010 to 2023.
What position did you hold while you worked there?
I was a forensic analyst.
And were you a forensic analyst for in 2023 you were a forensic analyst, correct?
Correct.
What training did you go through to become a forensic analyst, starting with your education?
I graduated from the College of Worcester in 2010 with a degree in biochemistry and molecular biology. And then I had an internship at the crime lab. And then I was hired on full-time. And I completed a 6-month in-house training program under the direct supervision of my supervisor at the time, where I completed supervised casework, competency tests, and in-house proficiency tests. And then I also would complete yearly training to keep up with my continuing education.
Did you have particular continuing education requirements?
Through our accrediting agency, we were required to complete at least one continuing education training per year, sorry.
Take your time, per year. Okay, and in the course of your employment at the Lake County Crime Lab, did you ever testify in trial?
Yes, I did.
Do you know approximately how many times you've provided trial testimony?
It was upwards of 50 times.
And you were qualified as an expert in those trials, is that
Yes, I
correct?
was.
Now, at some point during your employment with the crime lab, did you have a coworker by the name of Tyler Meter?
Yes, I did.
And in 2023, were you responsible for the bulk of the peer review of Tyler Meter's work?
Yes, I was.
Did you notice any deficiencies in his work at any point in time?
When I was reviewing his cases, I had to communicate with him to correct certain clerical errors that were occurring on his reports and and on his work product.
And through the course of your review, well, let me clarify really quick. You indicated that you had identified clerical errors. What is a clerical error to you?
A clerical error is just an error that occurs that has nothing to do with the scientific testing of the evidence. It has to do with the transcription from when he was writing either, or if I was even doing it, if you're writing onto your worksheet and then transcribing it to the work product and onto the report.
What's the purpose of highlighting clerical errors during the peer review process?
We wanted to ensure that all of our reports that were being reported at the time were going out with no errors, and we wanted everything to be consistent between all of the scientists in the section.
And what would the reason for that be?
Just consistency, so it would be easier to review when if we had people coming in to review it.
Okay. And from 2020 to 2023, who were the drug analysts working in the lab?
You had Supervisor William Kubek, the forensic analyst Tyler Meter, and myself, forensic analyst.
So of the members employed by the lab, there were 3 people during that 3-year time frame that were qualified to do drug analysis. Is that correct?
Correct.
How were those cases divided?
Well, William Kubek was the supervisor, and he had a lot of the administrative duties to do at the time. So he would do casework when he had time to do it. The marijuana cases were typically given to Tyler to work on, and then some of the, well, if you want to say quote unquote, easier cases of just cocaine or the simpler cases were given to Tyler, and then all the other cases were given to myself.
Would you say, just based on your impression, that resulted in an equal distribution of the caseload among the 3 employees?
With me doing it at the time, it did not seem equal.
Okay. Starting in 2023, was there a change in Tyler's work performance that you noticed?
I wouldn't say so much a change. It was just a continuation.
It was a continuation.
A continuation of asking him to correct clerical errors that I was noticing while reviewing his cases.
And when would you say, well, if this was not a change but a continuation, what led you to report Mr. Meter's work performance and deficiencies to Mr. Kubik later that year in 2023?
I had been reporting what I had been noticing throughout the entire time that I was reviewing his cases.
You had been reporting?
I had been reporting what I was noticing to Mr. Kubek.
As a result of you reporting what you noticed to Mr. Kubek, were any changes made to who was doing whose peer review?
There would be times that Mr. Kubek would review some cases, but no.
Okay. When did you first begin to notice the deficiencies in Mr. Meter's work performance?
It's hard to break it down by saying the deficiencies in it because he was freshly off of training, and you want to give, I don't want to say you want to give grace to allow them to get better.
Would it be fair to say that you extend additional leeway to newer analysts in light of their inexperience?
Yes, so that they can get used to what they're working with, because while you're training, it can only prepare you so much for actual casework.
So if you recall, when did Tyler Meter first begin doing his own casework?
I'm really bad with coming up with like a time frame because the last so many years have all just blended together for me, so,
Just
If you don't
answer-
recall,
Just
that's
answer it
okay.
if you know, that's all.
okay. I can't give you a direct time frame.
Do you recall a memorandum being placed in your file or a conversation with Mr. Kubik in 2020 about your supervision of Mr. Meter during his practical competency test?
Yes,
Would that be about the time that you began doing peer review of Mr. Meter's work?
yes,
And it appears, well, what we have here is in defense exhibit, you were using the motion labels, weren't you?
I mean, you can label anything you want, doesn't
All
matter.
right. So defense exhibit B. Is a memorandum for the record from your personnel file dated June 10th, 2020. Is that familiar to you?
yes.
Do you remember the substance of what you were? What is a memorandum for the record when it's in your personnel file?
It's, typically it comes from the director of the lab or from your supervisor, and it is to give a written documentation of conversations that were had pertaining to performance at the time.
Okay. So is it fair to say that you first noticed deficiencies in Mr. Meter's work when he first started doing his own casework, but attribute those to his inexperience?
That's correct.
At what point in an analyst's experience would you expect them to stop making such errors?
I don't think an analyst can ever 100% stop making errors due to us being human, but I would hope to see a change in those errors to decrease over time, where more caution is taken towards their work.
And so as a more experienced peer doing peer review of Mr. Meter's analysis, you would offer corrective suggestions, is that correct?
That's correct.
And what was the nature of those suggested corrections?
It goes back along the lines of trying to keep all of our reports and work product consistent within the section. So keeping, say, the abbreviations that we use consistent, keeping how the order that we put our work product in consistent amongst the analysts, just to name a few.
And were all of the suggestions that you made to me, Mr. Meter, in that 2023 timeframe clerical in nature?
For those suggestions, yes.
The
I
email, every email that you sent to Tyler Meter in 2023 was for a clerical correction?
I believe the emails were clerical,
Have you had an opportunity to review those emails ahead of this hearing?
very briefly.
Or maybe give her an opportunity to review the emails.
Go ahead. Do you have your sheet? Are they up there? I don't know where they are.
They have her.
I think they're right in front of her.
Should be F1 through F26.
Okay. So not, the majority of them are about clerical errors, but there are a few that are not, what I would not consider clerical errors.
Could you walk us through the few that you would not consider clerical errors?
Okay, so the first one, F1, shows a tech rejection. So the case was rejected due to, it doesn't give you a reason why, but if something's being tech rejected, then that means there is an issue with the report for it to be reported out. So it had to be kicked back for either something to be fixed or for more testing to be done. Defendant Exhibit F7 states that the ratio for item B should be it should be 48.65, so that means the calculation was done most likely incorrectly and needed to be fixed.
And what is the impact of that an incorrect calculation can have when we're talking about a scientific experiment that will at some point become evidence?
If you are basing your result based off of a calculation, and if that calculation was wrong, it could have an impact on your conclusion.
So a clerical error within a scientific report can lead to incorrect results.
If there's a calculation that's attached with it. Defendant's Exhibit F8 states that item 1C needed to be reported as inconclusive for both the report and the worksheet. Some could look at it as a clerical error. I do not recall how it was reported prior to this email. But if testing was done on something, some sort of scientific testing was done and you could not determine a result, you needed to report it as inconclusive.
Because, in fact, testing was done.
Testing was done on that. It says you did do testing with the IR.
And it would be incorrect if the report reflected that it was not.
Correct. Same with Defendant's Exhibit F9 states need to add residue to conclusion on worksheets for items 1B and 1C. If someone was reviewing just the worksheet and they did not see that residue, they could potentially come to a conclusion that an actual substance was identified. For Defendant's Exhibit F18, it's stated within the QC, the GCMS, on June 8th does not identify methadone in the library search for the 10.0 test mix. That was a part of our quality control that we had to make sure that our library was working properly and was identifying all of the drugs that was in our test mix. And then I do also have a note of nicotine retention time is 2.63 minutes, but I can't recall the reasoning for that being in the email. Either the nicotine retention time wasn't included on the worksheet for review, most likely that scenario.
And what is the impact of retention time on your testing procedures or the final report?
Part of our procedures was to The only way we could call a substance was if it fell within a 3% window of our library retention times that we ran on our instrumentation. So if it fell outside of that window, then you could not call it unless you got the standard, which is just like a commercial product of that drug that we could run on our instrumentation to qualify the retention time.
So retention time can impact the inclusion or exclusion of a substance in your result?
Correct.
And Ms. Gilson, if you
Yes.
actually just for clarity and purposes of the record, indicate the date on the report for Exhibit F18, I'm sorry, the email for Exhibit F18 as well as F19.
F18 was Thursday, June 22nd, 2023, and the same for F19.
Were there any additional reports that you found? Emails did not just reference clerical errors?
F20, I had for one of the cases, he did not upload any of the drug documentation for me to even do the review for the case. So there was no information for me to do a proper review at the time.
Would you describe that error as akin to leaving the email, the attachment off of an email that you meant to send? Or is it more significant than that?
It could be viewed that way.
And the date for F20 was?
That is Thursday, June 22nd, 2023. Defendant's Exhibit F23 states the MDMA retention time needed to be added to the worksheet so that review could be done. And Defendant's Exhibit F24 said in the library search for this case, it was showing a match to duloxetine for item 1. And if we have an identification to any substance from the lab's library, we have to investigate it to deem if it was actually that substance or not.
And do you have to do that even when there is a known issue where with a particular substance, another substance frequently appears?
Yes.
Is there such a relationship, to the best of your knowledge, between marijuana and duloxetine?
Yes.
And would an analyst, short on time, withdraw. How did you realize that the duloxetine match was missing from the report in F21?
Just going through the review of the case, you look at the library searches and then the analyst is supposed to put in the mass spectra data for any substances that are identified through the library to show whether they match or do not match.
And would failing to include a peak for another drug be a clerical error on a report?
It's just showing that the investigation was not complete of the case for that item.
So what additional work would need to be done?
Additional information is needed, yes.
What additional steps need to be taken to produce that additional information?
Yes. Yes, it would.
I'm asking
Oh, what specific, sorry.
Yes.
You would have to go back to the instrumentation and investigate the peak that is being identified as duloxetine through the library, print out the data that goes with that to show whether there was a match or not a match for that drug.
And are those several additional steps that are required?
Yes,
That would be required every time a duloxetine peak was identified with a marijuana sample?
yes,
Would that get tedious over time?
it does.
Now, and what was the date on that email as well?
That was Thursday, June 22nd, 2023.
How frequently during peer review are errors of any type, whether clerical or technical, identified, based on your experience?
You always aim to have 0 errors in your work, but if an occasional few clerical errors come through, you work with the analyst to resolve those errors so that you can review, you can technically review, and then send it off for admin review, that case.
And when you, so sometimes they come up. At what point does their frequency become alarming?
It would be if you're given a like say, give a scenario, if you're given a batch of 10 cases and you can't review any of the cases because something has to be fixed.
Is that similar to this scenario or situation you found yourself in on June 22nd when you were reviewing Mr. Meter's work?
Pretty similar.
Now, you indicated that part of the peer review and tech review process is to work with the analyst so that they adjust their performance to accommodate, to take care of these errors so they don't make them in the future. You indicated that you peer reviewed Tyler Meter's work extensively from 2020 to 23. Do you feel that the number of errors you encountered in his work decreased as you would expect?
It may have decreased slightly, but then it would kind of be like a wave, like it would decrease a little bit, then it would come back up.
And when there were periods where it came back up, and you identified those periods and that Mr. Meter's work, I guess, was becoming more frequently deficient than the norm, what steps would you take to bring some sort of correction to Mr. Meter?
I was a very open person where I would talk with him about them, and then I was always very open with Mr. Kubek about what I was observing, and always made him aware when I was reviewing cases, what I was seeing.
And when you would routinely make Mr. Kubek aware of what you were seeing, and did you ever bring to Mr. Kubek's attention that the type or volume of Mr. Meter's errors was causing you concern?
Yes.
And on the occasions that you did that, what steps did Mr. Kubek take to the best of your knowledge?
It always seemed to come down to, he said he would have a conversation with Tyler regarding his work product.
And after those conversations, would you...
Like I had said before, it would be like a wave of, it would be remedied for a period and then it would just come back up.
Would it be normal or acceptable would you consider it normal or acceptable for you to receive 6 emails from one batch of corrections that needed to be made that included both technical and clerical errors?
No.
And so that the reason that you reported Mr. Meter's deficiencies to Mr. Kubik on June 29th of 2023?
Yes.
And to the best of your knowledge, were any changes made to ensure that Mr. Meter's deficiencies would be addressed?
Not that I recall.
Is that consistent with your experience with reporting Mr. Meter's deficient performance to Mr. Kubik?
Yes.
Were you subject to scrutiny during your employment with the lab for similar things to what we're discussing regarding Mr. Meter? Similar issues.
Yes.
We talked about a memorandum from 2020.
Yes.
Do you know if another memorandum was ever placed in your file following a review or conversation with Mr. Kubik?
Yes.
Do you know when the next one was?
I can't give you a direct date. I know there was one in the fall of 2023.
There was. Was there one in 2021 as well?
Yes.
Do you remember the types of deficiencies that you were written up for in 2020 and 2021?
It had to do with the number of tech rejections I was receiving.
Let's get into the tech rejections. So a peer reviewer, where there are, would tech reject a report when?
If there's an issue between what is being seen in the work product and what is actually being reported on the report.
Does every person in the crime lab who conducted peer reviews follow that philosophy of tech rejection?
No.
When your work was peer reviewed by Mr. Kubik and tech rejections resulted, were they only for technical or were they for both technical and clerical errors?
Technical and clerical.
And do you routinely tech reject reports in your peer review that were clerical errors, on the basis of clerical errors?
No.
What would it require for you to reject a report or a draft?
There had to be an issue in what was being reported in the report. If there was, say, a drug missing, or if a different drug was put accidentally onto the report, or if, especially with weights, if the weights were reported wrong, that would deem a tech rejection from me.
So is it fair to say that you would tech reject when you felt an error was technical and substantial?
Yes.
And it's your impression that your work was often tech rejected for clerical errors?
Yes, for some of them, yes.
And it's your position that that is a difference in philosophy among peer reviewers?
Yes.
Do you recall the substance of any of the issues that were addressed in the 2020 or 2021 memorandums?
memorandums regarding her or Meter?
The 2020 memorandum relates to her and Mr. Meter. 2020 is Ms. Gilson and Mr. Meter within one memorandum. 2021 is just Ms. Gilson.
The 2020 memorandum had to do with my supervision of Mr. Meter. And if I recall, it had to do with something with his competency or proficiency testing that he was doing, and I had to review everything prior to him running his testing.
And the things that you were supposed to review prior to his testing, are those things that were part of peer review? Well, strike that. Those things that you were supposed to direct him to set up, are those things that it would be expected he would know, considering it was for his practical competency test?
Yes, he should.
Coming back to the substance of the memorandums from 2020 and 2021, regarding your own individual errors, just in 2020 and 2021, do you recall the nature or substance of those?
I think it was mostly to do with like tech rejections. I'd have to refresh my memory.
Your Honor, may I reflect a recollection? The memorandum from 2020 was previously marked Defense Exhibit B. The 2020 memorandum is now marked Defense Exhibit C.
So the 2020 memorandum, which is Exhibit B, the...
You don't need to describe it right now.
Okay.
I just
Go
want to
ahead.
make sure that
Yes.
your recollection is refreshed.
Yes, it's
With-
refreshed.
The nature of the errors, of your errors contained within the 2020 and 2021 reports, would you characterize them as similar in nature to the errors that are within the emails that you sent to Mr. Meter in 2023?
Portions of it are, yes.
But none of those errors in 2023, to the best of your knowledge, resulted in any disciplinary action against Mr. Meter, correct?
Not that I recall.
Do you view the memorandums placed in your file following verbal warnings as disciplinary action against you?
Yes.
So beginning in 2020, you noticed deficiencies in Mr. Meter's performance and attributed those to inexperience, correct?
Correct.
And over time, you noticed a significant number of, a number that to you was significant, of errors, clerical and technical, on Mr. Meter's part that you reported to Mr. Kubik, correct?
Correct.
And it is your impression and understanding that on each of those reports, no corrective action was taken until 2023, correct?
Correct.
No further questions.
Any cross?
Yes. So you brought these errors to the attention of Bill Kubek, who was your boss, correct?
Correct.
And you felt like he didn't do anything?
Correct.
Okay. And yet you got a memorandum of understanding in your file?
Correct.
Or whatever you call it.
Correct.
Now, is that memorandum considered
Are
discipline?
you talking about, identify which one you're talking about?
I don't know what exhibit she was showing. Both of them.
Well, there's exhibits from a memorandum from
Okay.
20 and one from 21. So let's make sure what we're talking about.
All right, and so in Defendant's Exhibit B, what are they saying about you?
I had 2 case rejections due to not identifying and reporting controlled substances.
Okay, so that document, is that considered discipline in your file?
That's how I view it, yes.
Okay, so calling your attention to document C, defense C. That's the same thing?
Correct.
So would you consider that discipline in your file?
Yes.
Okay, but you reported these errors to Mr. Kubik, and he didn't do anything?
Not to my knowledge. Nothing was done except talking to him.
Were you ever put on corrective action? You personally?
No.
Okay. Now, you talked about you wanted consistency throughout the lab. Do you recall that?
Yes.
Okay. Now, being consistent isn't necessarily lab policy, is that correct?
No. But it was what was expected of us in the drug section.
Okay, so you want everything to be consistent. So when you're reviewing his stuff, his worksheet, and it's not consistent, you would log that.
Yes.
Okay. Even though it might not be wrong?
Correct.
Okay. But that's just how you want things done.
And it was not just me though. That
Okay.
was put in place by Bill Kubek to do consistence.
Okay. Now, you were talking about defense F9, and you were talking about actual substance because he didn't put residue. You remember that?
Correct.
Okay. What's the difference between meth and meth residue?
Meth, there's a bulk amount that you can hold. It's tangible. A residue is, if you want to describe it as like dust on a surface.
Okay, but it still has some kind of weight to it, does it not? And the residue is an actual substance.
Yes, but not weighable in our standards of being able to report a weight.
Okay, but he's reporting that meth was present, correct?
Correct?
But he didn't put residue.
Correct.
Okay, so he got the drug correct. The process works, he just reported it in a way that you didn't like. Would that be fair to say?
Not just me not liking.
Okay. Now, a lot of things that you did too was that were noted to aid a reviewer. So that's the tech review part of it, right? So if my worksheet's wrong, you would ask to do this to aid the reviewer.
Correct.
Okay. So aiding the reviewer would be the tech review, right?
Aiding a tech reviewer, aiding the administrative reviewer, and aiding our reviewers when we would have the accreditation firm come in and review our reports.
Okay, so it doesn't mean that you got it wrong. It's just that this is what you need to do to make this the right process.
Correct.
Do you have State's Exhibit 1 up there?
Should be the drug results.
No.
I don't remember one.
What's that?
I don't remember it in Exhibit 1.
Right here.
Oh, I know, but I don't remember anybody identifying it.
Tyler Meter did not get it there. Showing you it's been marked for identification, State's Exhibit 1. Do you recognize State's Exhibit 1?
Yes.
Okay, and what is it?
This is a copy of a lab report for laboratory case number 23. 2020-478.
And do you recall reviewing that case?
I reviewed a lot of cases, but I do recall reviewing a case like this.
I know. Would you be surprised to know that you did the tech review on the case?
I would not be surprised.
Okay. Now, when you do the tech review, like say of that case, what are you doing?
Doing the tech review, you have to go through, start to finish in the case, checking to make sure all the quality control was done properly and it's present for review, going through all of the drug data, going through the descriptions to make sure your description of the evidence matches your report, making sure if there's any weights that they were transcribed correctly, making sure the drugs that were listed were transcribed directly, making sure you...
I'm sorry,
Sorry.
I cut you off. I'm sorry.
no. And then just making sure that everything is well documented and is able to be reviewed, showing, and then you can actually see the process that analyst did when they were performing the testing.
What was the report date on that?
The report date for this was June 23rd, 2023.
And that was right in the middle of all these other ones, is that correct?
Correct.
But yet there is no email regarding that report.
Not that I recall seeing, no.
Okay. But if you would have found incidents there, you would have wrote them
I would have, yes,
absolutely, correct?
yes,
Because you didn't hesitate before, right?
no,
Okay. So by the absence of your emails, because there is nothing in that series, then that report was fine?
yes, it was reviewed and published,
That his science would have been fine, that the results would have been fine?
yes.
Nothing further, thank you.
Any redirect?
Yes, Your Honor, briefly. You indicated on cross that consistency isn't lab policy. So the lab had requirements of you, and it was a preference but not a requirement that you be consistent. Is that what I'm doing?
That's fair to say, yes.
Okay. Now, we forget about the lab. Let's talk about science. You're a scientist, correct? You functioned as a scientist in your role as a drug analyst with the Lake County Crime Lab.
Yes, I did,
And you did that for 13 years,
yes.
approximately. Is consistency important in science?
Yes,
What does a lack of consistency produce when you're talking about science?
it produces errors,
And when you are not just working in a scientific lab, but a forensic lab, and your reports are made with the understanding that they'll become evidence, right?
correct,
So is the accuracy of your reports paramount?
yes,
And does inconsistent science produce consistent results?
no, it does not,
Now, Mr. Geigrich said when Mr. Meter tested that substance that didn't have residue attached to it, he got the substance right, right?
correct.
And that's all that matters, right?
It matters that you are reporting the correct thing,
Now, you've testified as an expert in drug trials before, correct?
correct.
Based on that, do you have a working understanding of how the weight that is measured impacts the outcome of a criminal case?
Yes,
And how is that?
to use your words, it is paramount for charges.
And that's because somebody can be found with crack cocaine in a residue amount, and that's one level of offense, correct?
Correct,
But if they have a measurable amount that exceeds bulk, it's not going to be the same level of offense, is it?
correct,
So Measurements matter.
Correct.
Weight matters.
Correct.
You talked a little bit about the notes and the worksheets of the analyst matching the final report. Now, sometimes the report, there are transcription errors in moving that information from the worksheet to the report, correct?
Correct.
Now,
You know, I'm going to object, Your Honor, it's way beyond the scope of my cross.
Rule.
Thank you.
now, if the worksheet is done properly, the drug analysis is flawless based on the work that you review, how much does that matter if the report doesn't match?
It matters a lot.
Explain.
If you did all your scientific work correctly and you had certain results, but then you're putting something else on your report, then you are reporting false information,
It's just-
actual.
So clerical errors, transcription errors, they matter in the sense of a forensic scientific lab.
They do.
No further questions.
Cross.
Just a second, Your Honor. Thank you. Now, we're talking about reporting, you know, and how things like drugs and how it ultimately plays out in court. If I report, say I have a bag of drugs and I report it as residue, does that change anything?
From my viewpoint of a scientist, it does, but I'm not the one trying the case.
Right, because what it does is just increase the level, right? So if I have residue, it's still a felony, right? If I have bulk, that makes it even more,
Correct.
because that's what you were talking about,
Yes.
right? So if I say it's residue and it's not, it's still the controlled substance. You identified that controlled substance, correct?
Correct.
Okay. And he identifies that it was, and what was he didn't say residue, the word residue, but he listed a weight for it too, didn't he? You'd have to. But it would be in the plus or minus.
With that particular instance, I cannot recall if there was a weight associated with it or not.
Okay. But it would still be sub 01 positive cocaine, schedule 2 plus or minus whatever that would.
If there was a weight associated with it,
Right.
yes.
And that would still be accurate, wouldn't it?
In that instance, if there was a weight
Because what was the
associated with it.
reporting limits that you had at the lab, do you recall? Where your results are reported plus or minus a certain amount?
That was to do with the, for the balance. It would have to do with the like calculation of error for the balance, like human error while using the balance, like it could be a plus or minus a certain weight.
Sure, so that residue could fall within that plus or that margin of error, correct?
If it was weighed, yes.
Did you see any instance where Tyler did not follow the correct methodology on the machines, that type stuff, testing the drugs themselves?
Not that I recall.
Okay, so when he's reporting it, that's where your problems come in.
Yes,
And then you get tech review and you get admin review, correct?
Yes,
And those problems are typically caught.
yes,
Because even you make
yes,
errors.
yes,
And at one time, you were considered probably the best drug analyst that there was at the lab, is that correct?
I cannot give myself that title.
Okay, but you make mistakes.
Yes,
Bill Kubik makes mistakes.
yes,
Leanne makes mistakes.
yes,
I'm sure Silverstein makes mistakes. Everybody does. It's just the reporting, correct?
yes,
But at the underlying science, there's nothing wrong with that.
correct.
And has drug chemistry changed since you studied chemistry in 10th grade?
No,
Nothing further, thank you.
All right, you may step down, thank you. Next witness.
We have no additional witnesses, Your Honor.
All right, would you like to argue this motion? It's up to you.
You went first. Did you want to close first?
You?
Your Honor, you've heard the facts, you have the brief. We'd ask you to over or deny the motion. Thank you.
Okay.
Your Honor, Mr. Rucker takes no issue with the scientific methods that are employed for drug testing. He has a firm understanding that the test procedures used to identify and weigh controlled substances are well established and accepted in science. The issue before the court here is whether or not Mr. Meter's reporting and the work underlying that report reflects a reliable application of the science. And it's our position that it does not. His supervisors noticed, his peer reviewer noticed errors across time. She routinely brought those to her supervisor. It was her impression and understanding that no corrective action was taken. And Your Honor, that's consistent with the corrective action taken.
Didn't they testify that there was corrective action taken? Are you talking about with
I'm-
regard to Meter?
Your Honor, I misspoke. Disciplinary action. And that perhaps it was certainly a focus here, but perhaps erroneously. The question before the court isn't whether what was done was criminal, whether what was done was intentional, whether what was done was clerical or technical in nature. The question is whether or not the volume and frequency of the errors and the failure for any correction to be implemented renders results upon which we can rely. Clerical errors matter in science. Consistency matters in science. Following lab procedures matters in science. It's why those procedures exist. When we allow analysts to start cutting corners because they don't want to redo a step in a test for marijuana when they know exactly why this other substance is identified. There were problems that led to unreliable work performance, and the science requires consistency. It requires striving for perfection, and we have margins of error to account for human error. But what was occurring in the crime lab at the time doesn't fall within that margin of error, and it's why Ms. Gilson saw it fit to report it to Mr. Kubik. It's why Mr. Kubik, despite his history of not making any changes or implementing any corrective action or disciplinary action with Mr. Meter, actually led him to do something. It is rather unique that the corrective action pertains to the acts of one individual analyst among corrective actions. And to say that it is not an extraordinary circumstance for corrective action to be implemented is just contrary to the evidence, Your Honor. 15 times in 5 years, the lab asked the question whether or not corrective action was needed. 3, 4, only 7 of those times was corrective action actually needed, and one of those 7 times was Tyler Meter because of the volume and frequency of his inconsistent performance. And it is all directly relevant to the testing in Mr. Rucker's case because it's the volume of errors in the same batch as his case that led to the corrective action in this case, Your Honor.
When did that happen?
As such,
Who testified?
the evidence here, the testimony of Mr. Meter cannot be relied upon. His application, practical application of what he's learned, does not give us the certainty that we require, that the court requires when we are considering sending somebody to prison.
Now, we're talking about, you mentioned that the margin of error, that there's going to be error. What is the acceptable margin of error? Because now, we're talking about error as it exists from note-taking, as it then gets applied and produced in a report, correct? That's the margin of error we're talking about. Is that not correct?
No, the margin of error, as reported.
Where the errors occur. That's what.
The margin of error is plus or minus specific weight based
Okay,
on.
I'm talking, I guess I didn't make myself clear. There are the emails F1 to 26, all are applicable to a report that Meter produced, right?
Correct.
Where there was some variance, be it small or big, that go from his notes that he's taken as he's doing the analysis to the production of the report, correct?
Correct, Your Honor.
Those are where the errors occur.
And that margin of error per analyst is something that's my understanding is kept by accredited labs. It's something that we requested and through public records request. It came back that it was overly burdensome. We were working to tailor that request. It was not tailored.
So then the purpose of the tech review or peer review, whichever you want to call it, is to then for somebody else to make a comparison of the notes to the report produced by the analyst, and if there's a problem, to correct that problem. Isn't that right?
My understanding is that tech review, they reviewed the notes, but they're not just looking for clerical errors.
I'm not talking about
Okay.
any error, be it clerical or be it the wrong drug. Whatever variance there is from the notes to the produced report, the purpose of the tech review is to reconcile those and send it back if necessary to correct a report, right? Make it consistent with the notes. Isn't that what we heard all day?
I believe it does extend beyond that they are actually, based on what they are reviewing and their understanding of how the testing is done, that's where there are some things they can tell from the report. Sometimes they have to go back and check the numbers in the machine.
Okay, but whatever it is, the purpose of the tech or peer review is to identify any inconsistencies to ultimately get the correct report, correct, with the correct result.
Correct, Your Honor.
And as you've indicated, there's no issue with the methodology of the science behind the analysis, isn't that right?
Correct.
Okay. All right, anything else? Do you want to say something?
No, Your Honor, I was just going to add that the peer review takes into account the data that's contained within the machines.
Okay. All right, I will take it under advisement. I'll give you a written decision on the motion in limine, which, as I will remind you, is the preliminary ruling on the motion.
All right.